MLRB board meeting. And I think where we are is Mr. Justice, you're still on the spot. I don't know how much time. 1 hour is enough. Now let's make it about 30 minutes.
Good. If I may inquire, what about objectors? You were going to calculate that for us? Would you please? Thank you.
Any other questions before we begin?
Just to clarify, I have used 1 hour and 6 minutes, or I have 1 hour and 6 minutes remaining?
You have an hour and 6 minutes remaining.
Okay, thank you.
Okay, you're up.
When we last finished, we finished the testimony of Mr. Berry. Previously, Mr. Beckwith had agreed to go out of order to allow that testimony, and he still has the opportunity to cross-examine Mr. Hill. Mr. Beckwith, you have that opportunity this time. Do you want to?
For the record, Jim Beckwith, attorney registration 2295. I'm sorry, I'm a creature of habit. But as I indicated to John before we started, I do not have any questions of Mr. Hill, but I do not know if Mr. Carey's attorney has any questions.
Mr. Phillips, do you have any questions?
Just a second, please. Call off guard. Yeah, first question is.
Why don't we call Mr. Hill up to the podium if there's going to be a cross-examination?
What? Mr. Hill, the test that it's called an ERT.
Yes.
Okay, what's the difference between the electric resistivity of water as opposed to air?
Water is much more conductive. It's conductivity inverse of resistivity, so air is much more resistant. That's why it takes a lot of voltage to get any kind of electrical current through air, while water is much more conductive, and the range of conductivity varies usually absolutely in water with how much mineral salts are dissolved in general.
Would it be fair to say they're at the opposite end of the spectrum, with air being the most resistant and water being the least?
Generally, there are things more less resistant than water, but I mean, there's a huge difference between the two.
But not what you'd expect to find in the area where these tests were being conducted.
The most conductive, pure water itself is not all that, conductive. As you start putting in ions, as it becomes more conductive. So we didn't do any testing of the absolute resistivity of water in the area. So it may or may not be the most conductive component in there. The clays combined with water are likely more conductive than the water itself.
Now, we're dealing here with a collapsed mine working, correct?
Yes. Well, I can't say that.
Objection, he didn't testify that this is a collapsed mine working.
I'd like you to assume that this is a collapsed mine working from the testimony that's been presented.
Other people can make that.
Objection, this is beyond the scope. He did not offer any testimony on that or speculation on whether this is a collapsed mine working or otherwise.
All right, generally speaking, I'll withdraw that question. Generally speaking, if you're running one of these tests and you've got a void that is partially filled with water and partially filled with air, how does that show up on your test?
It depends on the minerals that it's encased in. There are three main ways that you can conduct electricity in the ground. Generally through the water itself, through ionic conduction, through metallic minerals, like pyrite or galena, some of these other type of minerals.
I can't hear you.
Okay. I apologize.
I have pyrite, but I can't hear
Okay. I apologize. Anyways, there is little of that out there, we suspect. So most likely the third method, which is the conductivity of conductance of electricity along the surface of clay minerals. And you need a clay mineral and a water adhering to that. So you have a clay mineral water interface. And certain clays, you develop ions adjacent to the clay mineral itself. So within the certain number of layers from the clay mineral itself, you will be able to conduct electricity. So if you have a completely dry void, you would expect that relatively all other factors being the same to be more resistive than if you had a partially or fully saturated void with clay minerals. Now, if you don't have clay minerals, you have minerals that aren't clay, like quartz, which is the other common mineral out here, you would have lower resistivity. So you can make generalities about that.
Do you believe a sufficient number of tests were conducted on the site to determine where there were void spaces and possible paths or hydrologic communication?
I mean, I can only make an opinion on that in the area that we tested.
Who directed you to test it in that specific area?
Discussions with Mr. Berry.
That's all the questions I have.
Okay. Mr. Justice?
I don't have anything further on redirect. Thank you.
Okay.
Thank you. Does the board have any questions for Mr. Hill before?
I do. The tests that were decided upon, were they decided upon mutually, or did Mr. Berry make the final decision on which tests should be conducted?
They were, Mr. Berry approached us on what may be useful testing in this area for the objective of trying to find pathways from the surface underground. And I offered up several methods based on, cost and whatnot. And I think in the end, it was mutual discussion. I know I probably drove the discussion, but it was a mutual agreement with Mr. Berry.
Was in the discussion with Mr. Berry, was there any discussion at all of any role that the river could have played with the rising and lowering of the water table, that it can affect?
No, we did not discuss the river, no.
Any reason why not?
The river is several hundred feet below where we were doing the tests.
Okay.
And we were looking for pathways for surface or near surface water to possibly migrate down.
But it couldn't have migrated across and then gone up.
Well, that's a hydrologic question. That's not my expertise.
Oh, okay. All right. Mr. Berry would have been the one who would have had to make that decision then.
I assume that's but I.
Okay, thank you.
Sure.
I guess you're excused.
Okay, thank you.
Next, Snowcap would like to call Mr. James Stover. Sit down. We already went over that.
Okay.
Mr. Stover, you previously swore to tell the truth yesterday. That obligation continues. Would you go ahead and please state your name and business address for the record?
James Stover, 2352 North 7th Street, Unit B, Grand Junction, Colorado.
And where are you employed?
J.E. Stover and Associates.
And what's your position, J.E. Stover Associates?
Well, I'm president and consulting engineer.
Okay. Do you have any professional licensures or certifications?
Yes, I'm licensed in Colorado as a PE in 1982, in Utah in 2002.
Okay. Would you please summarize for the board your undergraduate education?
College.
Yeah.
Okay, I received a Bachelor of Science degree in Civil Engineering from the University of Utah in 1972.
Would you please give a short summary of your employment history after college?
Yes, I first went to work for Morrison Knudsen. They were a large multinational construction company. I worked on a couple of earth fill embankment dams, a pumping plant on one of them. I worked in their fabrication shop, and then I accepted an assignment to move down to Rangeley and work on the Rio Blanco oil shale project. I worked there for 4 years. After that, I moved to Grand Junction to open up their area office to support the oil shale industry. Unfortunately, the oil industry crashed in 1982. I was fortunate enough to negotiate a consulting agreement with Powderhorn Coal Company. And so I worked for 2 years as a consultant to Powderhorn Coal Company, doing really drainage design, sediment ponds, and facilities construction.
Mr. Stover, what was the mining facility that you primarily worked at in that relationship?
Well, Snowcap Coal Company is my roadside mine.
Okay, thank you. Go ahead, please continue.
Okay. And then in 84, I was fortunate enough to be hired directly by Powderhorn Coal Company as chief engineer. I was responsible for all engineering support, the surveying, and support systems design. And then in 1988, I formed J.E. Stover and Associates.
What is J.E. Stover and Associates' primary area of service?
The coal industry.
Okay. What kind of services do you provide in professional capacity for the coal industry?
We prepare design, reserve analysis, design sediment ponds, runoff, have designed coal mine waste piles. Over 29 years, we've done almost anything you could think of at a underground coal mine.
All right. Do you have much work in the area of reclamation and permitting?
Yes, all the work is really in permitting and reclamation. We've reclaimed 3 coal mines, actually 4, and got final bond release on 3 of those.
Okay. Would you go ahead and turn to Exhibit A47 in your binder? Next.
Okay,
Could you tell me what that exhibit is?
that's my resume.
Okay. Who prepared it?
I did,
And do you believe it is an accurate statement of your education and experience?
yes.
All right. Members of the board, at this time, I'd like to admit Exhibit A47 into evidence.
No objection.
No, dude.
And then secondly, I'd like to qualify Mr. Stover pursuant to Rule 702 of the Rules of Evidence to express expert opinions concerning coal mine operations, permitting, and reclamation.
Ed, what year? You have a few questions, sir?
Give a brief.
Do you have any particular expertise as a hydrologist, sir?
No.
No objection to the qualification.
Exhibits admitted and witnesses qualified.
Thank you. Mr. Stover, were you present for the earlier testimony of Mr. Boulay?
I was.
And would you please describe your familiarity with the June 2014 incident he described in his testimony?
Say that again.
Would you please describe your familiarity and understanding of the June 2014 incident?
Well, okay. Yes, I was there at the site with Mike and Rudy.
Okay. Was anyone else with you?
I think it was Mike and I and Rudy.
Okay. Where did you observe water being delivered to Mr. Fontenari's property on that date?
Well, Mr. Fontenary had excavated a trench to the north, and he was running water into that ditch, and it was coming to the end of the ditch where it 90s and the water was flowing back to the east and disappearing.
Did you see water being applied or delivered to any other location on Mr. Fontenari's property that day?
Well, some of the water would have gone on down into Mr. Carey's pond.
But that wasn't on Mr. Fontenari's property?
Right. Well, no, it's not. And there was no effort to use that water to irrigate crops or anything like that.
Okay. What about, did you observe any water in the Carey Pond? It sounds like that you did.
Yes, there's water in the Carey Pond.
Was any of that water being released from the pond for irrigation purposes?
No, it was not.
Okay. Mr. Stark and Mr. Boulay indicated that they had concerns about the south portal and seepage from that. How did J.E. Stover coordinate Snowcap's response to those concerns?
Well, Snowcap was likely also concerned about the stability of the portal. So we got in touch with Huddleston Berry, Mike Berry, had him come out and take a look at it and give us a report.
Okay. Was there any ongoing monitoring?
Yes, we were monitoring the flows daily for about 2 months until they subsided.
Okay. How did Snowcap decide to address the hydrologic communication that Mr. Boulay and yourself observed and it was documented in his 2014 report?
Well, we agreed to repair and fix the hydrologic communications through MR82.
Okay. I previously visited with Mr. Beckwith about the submittal of MR82 into evidence. It is the minor revision to the permit. It is, we believe, part of the record, but Snowcap would like to have that submitted into evidence. Let me find I think it's A27. Give the objectors an opportunity to review that, but we would like to have that submitted into evidence as the revision to the permit to address the hydrologic communication.
Is this a one-page or multiple page?
It's just
It
a
is,
single page.
it is a 2-page document. It has the approval sheet, and it has the subsequent attachment, which would be the inclusion in the permit.
The text.
Yes.
We have no objection. It is already in part of the record, but we have no objection to it being an exhibit.
Mr. Stokes.
827 is admitted.
What steps did Snowcap then take through your office to comply with MR82, which was Exhibit A27?
The first thing we did was have the investigation done to determine how the water was getting down into the abandoned workings.
Okay. And who did you hire or task to do that?
Well, it was ERT through Huddleston Berry.
Okay.
Or ERT. It was Fugro through Mike Berry.
Okay. And did you subsequently submit the results of that initial investigation to the RMS?
Yes, we did.
All right. I'd like to have you look at Exhibit A30. Sorry, A29, I think. No, A30, I apologize. Is this that submittal?
Yes, it is.
And does that contain as attachments the Fugro report and the Huddleston-Berry, no, the Fugro report previously discussed?
Yes.
Okay. I'd like to submit Exhibit A30.
No objection.
When did you subsequently submit the repair plan required by MR 82?
The repair plan,
Yes.
sometime in August of 2016 or 15.
Why don't I
Yeah.
direct you to Exhibit 34? That'll help you refresh your recollection.
September 27th, 2016.
All right. And did that include a repair plan?
Yes, it did.
Okay. And that was based upon information. How did you develop that repair plan?
It was based on the two ERT studies that Fugro did, as well
Okay.
as HBET's reports.
All right. I'd seek to admit Exhibit A34.
No objection.
No, good.
Thank you.
Sorry, sir.
Did you receive any notice, or did Snowcap Coal receive any notice that it had submitted a complete application?
Yes, it did. On a letter dated October 7th, 2016.
Would you turn to Exhibit A36?
Yes,
And would you tell me if that's that letter?
that is the letter. It's a completeness letter.
Seek to admit Exhibit A36.
No objection.
Could you please turn to Exhibit A37?
Okay.
Would you please tell me what Exhibit A37 is?
It's a letter transmitting the proof of publication for the technical revision.
All right, and what is attached to that?
It's it's a certificate from it's a proof of publication from the Daily Sentinel.
All right. Seek to admit Exhibit A37.
This is for the repair plan?
This is the notice of application for technical revision.
No objection.
Okay.
Thank you. Did Snowcap subsequently receive any comments on its proposed repair plan from DRMS?
Snowcap did get comments.
If you look at Exhibit A38 and tell me what that is.
That is a letter dated November 4th, 2016 from the DRMS that lays out their adequacy review comments.
Okay. Did Snowcap prepare a response to this?
Snowcap did.
All right. First, I'd like to admit Exhibit A38.
No objection.
No, good.
You said there was a response. Would you please turn to Exhibit A40 and tell me what that is?
That is the December 6, 2016 response to their adequacy comments.
Okay. Does this response contain a revised repair and replacement or repair and reclamation plan responding to DRMS's comments?
It does.
All right. Why don't we go ahead and talk about that repair and reclamation plan as Snowcap proposes to move forward at this time? I believe it's set forth in item, or it would be 14-33. If you look at the bottom right-hand corner of that exhibit, it's,
Okay, I got it.
you found it, page 99.
That's just what exhibit are we on again? I'm sorry.
We're still on exhibit A40.
E40, thank you, sorry.
And why don't we go ahead and, can you walk us through this repair plan?
Okay,
And I want to first ask, who prepared this?
I prepared it.
Okay. And you have the exhibit in front of you. Why don't you talk the board through what SNOCAP is proposing? And as an aide, could I have Mr. Stark or Mr. Schultz, Mr. Stark, put up the exhibit you had at the end of, I think it's exhibit beta from yesterday? Exactly, number 10. That would allow.
Let me go through the background.
Yeah, please, we'll talk about background. Oh, actually, maybe we don't need to.
Aging eyes.
We've already talked about it.
Yeah. With fruit row and Hudson Berry. We can jump to.
I think we can.
We could jump to that.
That's
One of 10.
10.
It's up to you.
So I think we'll lay a foundation here.
Okay.
Did you rely on?
Okay.
In preparing this plan, whose work did you rely on?
It was Fugro and Huddleston Berries mainly.
Okay. And do reclamation plans and experts generally rely upon investigations by other experts, geotechnical engineers or geophysicists?
Yes, we frequently use other experts to give us information necessary to do a reclamation plan, stability work, and that sort of thing.
Okay. I think before we go on, one of the things I want to clear up is some discussion we had yesterday about a rock pile. Yeah, see if I can move this back on this same exhibit. I don't move this back, do you?
Right click, and then there's previous.
There we go.
You can also use the buttons on the keyboard.
The arrow button.
Oh, okay. That will help. Oh, I went too fast. All right. Mr. Stover, are you familiar with the area that we've been discussing for the last 2 days?
Yes,
All right. And yesterday we heard a lot of discussion and cross-examination about this rock pile, where it was located, and what this represents as far as whether it is the location of the air shaft or something else. Where is this rock pile located on the map? And I'm going to go down a couple. We'll use the Fugro map since that was the focus of that discussion. If you could use this pointer and point out for the board exactly where that rock pile is located.
too shaky.
Okay. And what is the blue line immediately to the east of that location?
That's the U water line, and that rock pile is very close to that line.
Okay. As far as where the location of the vent shaft has been marked, do you believe that's appropriate?
Yes, that's the yellow circle with the cross in the middle of it. That's where the vent shaft is located.
All right. And you have compared that location to the old mining maps?
Yes, I have. Yeah.
Why don't we go back up and look? Would you believe that representation is accurate?
Yes.
Okay. Now, I want to ask you, have you seen or observed any at this location that a vent shaft might have once been located there?
Yes, that area has a slight mounding of soil over it. Kind of indicates that it was a backfilled air shaft. And there's also nearby some coal finds that are located north and west of that site, which would indicate that a fan was located or operating there and blowing a few coal finds out onto the surface.
So do you generally find those mine maps to be reliable? Okay. And you have also seen these physical characteristics at that location?
I have.
Okay. So going back, make sure if I can operate this to, do you believe the statement in this slide is correct, that that is the actual vent shaft location is accurate?
No, it's not. That is incorrect, and any references to that picture as the vent shaft location should be corrected.
Okay. Thank you. Why don't we now go ahead and talk about the repair plan? And we're going to move back to a slide, I think it's 10 or 11 of this Exhibit A, slide 10, or Exhibit B of the state. Why don't you walk us through, and you can use your repair plan submitted in December of 2016 as our point of reference, and talk the board through that repair plan.
If we do, could we enlarge?
Yeah, let me see.
Extent?
Yeah.
I don't know how it's done.
Do I need to kill this?
Skills.
There we go.
Thank you. It's just more readable. Thank you.
All right. And if you need to use the pointer at all to guide the board, please do. But
I don't know if I can. Okay, the contour interval there is 2 foot intervals.
the contour interval where, Jim?
Up on the repair plan area is really it's where the contour intervals are, up in that area.
Is this what we're talking about?
Yes.
Okay.
And the plan is to go in, strip the topsoil off the site, and then excavate down from west to east to follow the anomaly over to the air shaft.
So it would move from what you described in this point?
Yes, west to east, along that to the air shaft. And of course, the slopes, you have to have slopes down to the air shaft where it's safe to work. So that's the slopes to the west.
Okay. Okay, I see what you're saying.
And then to the north of that, we would excavate down and expose the north anomaly.
Is this
in that area? Yes.
Okay.
And all the material coming out of there will go into the soil stockpile. Located, no, that's the topsoil. The soil stockpile located where the pointer is.
Okay.
And then the plan is to, once we uncover the air shaft at about a depth of 16 feet, we would pour a concrete plug in that shaft. We would then...
How deep or how thick would that?
12-inch thick.
Okay. Do you have any sense of what the circumference of that plug might be?
It would probably be 8 to 10 feet in diameter.
Is Snowcap willing to or going to adjust how large that is based on what it finds on the excavation?
Yes, I mean that's as we excavate down, we may go a little deeper. We have to follow the anomaly.
Okay, so that's the intent then, is to follow the anomaly?
Right.
Okay.
And then once we pour the plug, we would then bring back the soil, backfill it, and compact it back up to original ground, less the topsoil depth. And then we would replace the topsoil over the disturbed areas.
Okay. What about reclamation of the site? Clearly, have we defined anywhere, or have you defined anywhere that disturbed area that's going to be?
0.4 acres on the site right there.
And is that,
That's the blue, kind of bluish line there.
okay. How does SNOCAP propose to reclaim that surface area?
Well, we would rip, if necessary, if we get some compaction in there, we would rip the area to promote root penetration.
Okay.
And then we would seed it with a seed mix that's defined in the permit for upland areas. And then we would mulch it with weed-free mulch.
Okay. Was the vegetative recovery plan that you proposed and the monitoring approved by DRMS?
Yes.
Okay. Did you submit a cost estimate for what it would take to complete this?
Yes, I did. The cost estimate would be to both excavate, place the concrete slab, and to reclaim it, backfill it, and reclaim it.
Would you turn to the last page of Exhibit 40? A40, I apologize.
Yes,
Is this where the cost estimate is set forth?
it is.
Okay. Move to admit Exhibit A40 as its submittal of a revised repair plan.
Okay.
Okay.
Submitted.
Next, I'd like to ask one last question. On what basis is Snowcap Coal asserting its right to entry to complete this reclamation and repair plan on this tract owned by Mr. Fontenary?
When Snowcap sold the property to Mr. Fontenary in
Can I change here
2000,
say, this is a document, there's no reason for this witness to testify to the creation of the document, he was not involved.
All right, let me try a different question. Would you please turn to Exhibit 49, A49?
Oh.
Would you please tell me what this document is?
It's a special warranty deed between Snowcap Coal Company, Rudolph and Ethel Fontenary.
Okay. Is this the document Snowcap relies upon its right of entry to complete this repair and reclamation plan?
Yes, it is.
Move to submit Exhibit A49.
I only object to preserve the record, you already know our position with regards to this.
Aye. No good.
Submitted.
Okay. Mr. Stover, I don't have any additional questions for you at the moment. I may ask you back for redirect. I'll ask you to sit for Mr. Beckwith and Mr. Spence.
I have a question. Going back to this pile of rock, does this have any bearing on the reclamation at all? This here, you're saying this is not the vent shaft. Is it anything that you recognize that would be utilized or involved in the reclamation?
No, it's not. It's not within the reclaimed area, and it has nothing to do with it. I believe that pile of rock came from the Ute water line construction. As they were excavating for the water line, they probably hit some big rocks as they were excavating that weren't suitable to use as backfill. And so that at some point they got all these rocks together, dug a hole and buried them.
And the rocks go beneath the soil
Yes,
surface?
yes.
You have any idea how far down?
I don't.
Thank you.
Just one question. Mr. Stover, you are familiar with track 71 as depicted on page 10 up on the screen?
Yes,
And does it slope from east to west? The surface, does it slope from east to west, with east being higher than the western end?
yes, it does.
Thank you. No further questions.
Mr. Stover testified, I believe, that you observed water flowing across the property as a result of your irrigation gates being opened in June of 2014. Is that correct?
We saw water flowing in the trench that Mr. Fontenary had excavated.
And you said some of that water went into the Terry Pond, and some of it went into the sinkhole that was close to the pier.
Yes.
Did you do any investigations concerning the water that was going into the pond?
No.
So we're only dealing with, say, a portion of the water that was coming through the irrigation ditch.
Well,
You need to confer with your counsel before you answer that question. If so, I'm going to object to that.
I throw one in, whether we investigated the pond, I mean, Fugro did run a line through the pond and didn't find any anomaly.
Do you have an opinion as to where the water in the Terry Pond is eventually going?
It's
That's
going,
beyond the scope of direct.
No, it is not, because he testified that the water was going into the Terry Pond.
He did not offer an opinion as to where it went. He just said that is where it went.
I would sustain the objection.
Yeah, I would sustain objection.
But in any event, there were no investigations made regarding the water that was going into the Terry Pond.
well, there was the Fugro report. That when the pond was dry, we ran a ERT line through there.
Did you ever go to the portal of the mine to see if any water was flowing out?
At what, when?
In June of 2014, when you were at the property.
Well, yes.
Right? Did you ever ask Mr. Fontenary and Mr. Carey to stop running water through the ditch and across the property?
I didn't make that request, but that request was made.
It was made.
Yes.
And would that indicate to you that the water going across the property, including the water into the Terry Pond, was somehow communicating with the mine workings?
Mr. Stover did not offer any opinions or testimony on that basis. That was Mr. Berry. I'm going to object again.
This is a question about, a factual question, not an opinion.
You asked for an expert.
No, I did not.
Okay. My
Restate your objection.
objection or question.
Yes.
My objection is that he is asking Mr. Stover to speculate regarding how water traveled, or if it traveled, from the pond to the south portal.
I sustain your objection.
The request was made, however, that Mr. Carey and Mr. Fontenary stop running water across the property. You're aware of that request?
Yes.
Do you know who made that request?
I would guess Tanya did. Tanya Hammond.
Was this at a time where there was some concern about a possible blowout at the portal?
Yes.
And did anyone ever tell you, express an opinion to you about where that water was coming from?
We believed it was coming through this anomaly that and down the path.
And you didn't believe it was coming from anywhere else?
Correct.
What was the elevation at the bottom of the shaft on the Cherry Pond, do you know?
Objection, Mr. Stover did not testify regarding the shaft of the Carey Pond or otherwise.
He testified about the Cherry Pond. He's testified about the water. I don't know why there's an effort to conceal what's going on here. We're trying to demonstrate that this plan only deals with, say, half the water that is the problem here.
I sustain the objection.
Well, it's also on his exhibit.
It was not submitted into evidence to the board.
I'll offer it at this point.
Which exhibit?
B10.
It is.
No, it is fine.
He did not testify regarding the shaft.
No, I'm just saying.
That is an exhibit. He has not offered testimony on the shaft in the Cary Pond.
I sustain the objection, and if you want to submit an amendment, you can do that. I mean, you can do it when it's your turn. You want to sustain an exhibit.
So we don't want to try to reach the possibility that this water is flowing.
We'll do it when it's your turn.
Can you confirm that exhibit B is already?
Yes.
This one.
That's all the questions I have.
2 quick questions from the division.
Did. There we go. Not responsive.
Scott Schultz on behalf of the division. Mr. Stover, what is the current vegetation at the site, specifically track 71?
It's cheat grass and other annual grass. There's nothing on track 71 that is of any value.
The seed mix that is proposed under application TR 69 will not include weeds such as cheatgrass, correct?
No, it won't.
Okay. No further questions. Thank you, Mr. Stover.
Any questions from the board?
See none. Go ahead, Mr. Justice.
Mr. Stover, you done? Ms. Hammond, would you please come up?
Mr. Justice, how many more witnesses do you intend to call?
This is the last witness, and it should be for a very limited purpose.
All right, you have 33 minutes and 42 seconds.
Thank you. Ms. Hammond, you were previously
I'll be precise.
sworn in. Would you please tell the board, for the record, your name and business address?
It's Tanya Hammond. It's 2352 North 7th Street, Unit B, Grand Junction, Colorado.
And who do you work for?
I work for J.E. Stover and Associates.
What is your role at J.E. Stover and Associates?
I am the owner's representative for Snowcap Coal Company.
All right. Were you here for the testimony of Mr. Berry yesterday?
Yes, I was.
And he indicated that he'd made several site visits in June of 2014. Is that correct?
Yes, he made a site visit in June of 2014.
Were you present with him at that site visit?
Yes, I was.
Would you please tell us what you saw with respect to water in the Cary Pond and/or the Fontenary Trench on the dates of that visit?
I met with Mike Berry on the 18th of June, originally at the South Portal. The seepage was coming out. We looked at that, and then we went up to the top, and we looked at the trench and the ditches and the pond. The ditches were not flowing at the time, but they were damp. And there was water in the pond on that day,
Okay,
on the 18th.
right. Did you make any subsequent site visits with Mr. Berry over the next year and a half?
Yes, he was out there a couple more times. We went out after I had noticed some pits being dug out there by Mr. Fontenary in the pond, and one other one by the power poles. So he came out to take a look at the soils in those holes and to look at the area there.
Okay. Was his suggestion yesterday that the pond was dry on June 18th correct in your?
Not in my opinion, no.
Okay. Thank you. Next question is, when did Snowcap request that the Division of Water Resources stop allowing Mr. Fontenary to divert water?
First of all, I was with Mr. Boulay on the 17th of June when he made the phone call to Mr. Fontenary and asked him to turn the water off. And then I was doing daily monitoring of the site.
When?
Starting the 18th, and the daily went through the end of June. And then I started doing weekly until the middle of August. But on Sunday, I believe it was a Sunday, it was a weekend, the 22nd, I noticed the water had been turned back on. So I contacted DRMS the next day, and they contacted the Division of Water Resources, and they came out and locked his head gate,
Okay.
Mr. Fontenary's head gate, and turned the water back off.
Thank you. Nothing more.
Okay.
When you say the 22nd of August? or June?
No, June, I'm sorry.
No further questions.
Mr. Stokes?
Excuse me.
And when you contacted the water division, did you expect the flow of water to be stopped to the pond as well as the ditch?
I didn't contact the Division of Water
Well, whoever you
Resources,
contacted.
DRMS did.
What was your expectation?
Our expectation was for the water to be turned off because it was causing issues at our portal.
Water flowing into the pond as well?
I don't know which water it was. It was water.
I need you to let him finish before you start. I didn't hear your question.
Okay.
And to the pond as well as to the ditch?
The water was flowing to both areas.
You testified that the pond was not dry on June 18th.
Not to my recollection.
Did you ever go to the site and observe the pond after that date?
Almost on a daily and now weekly basis, yes.
Did you ever observe the pond in a dry condition?
Many times.
And how soon was this after June 18th?
How soon was it dry?
Yeah, how many days?
I can't tell you that. I don't know off the top of my head. If it was dry that next week or 2 weeks, I don't know.
But eventually.
Eventually it dried, yes.
No other questions?
Any more questions? Snowcap rests its case.
Doesn't matter, you're next, according to the pre-hearing order. Yes, no problem. Oh, I'm sorry. We do not present anything for. Thank you, Scott.
Mr. Stokes, do you have
Yes.
a presentation or anything?
Fontenary does not, I'm sorry. Fontenary does not make a presentation at this time, but I believe Mr. Carey
We can change positions here.
will. Sure.
One and a half hours.
140.
And the mic is on.
Mr. Stutz and Mr. Beckwith, you have a combined hour and 40 minutes.
Left.
Yes.
Would you please state your name and address?
Jason Carey, and 920 Rapid Creek Road is the property I own in Palisade, Colorado. My physical address where I live, 66 Buffalo Lane, Carbondale, Colorado.
And what is your occupation and profession, sir?
I'm a professional engineer.
Could you tell the board what your educational background is?
Yes, I'm educated. I have a Bachelor of Science degree in physics from Fort Lewis College and a Master's of Science in civil engineering, water resources, and environmental engineering from the University of Utah.
One question before we get further in this. Mr. Stutz, are you intending to present Mr. Carey as an expert witness in this proceeding?
I don't understand what the interruption here is all about. That's not the appropriate time to answer this question. We're going into his background.
Carry on.
Okay, could you tell the board something about your experience?
Sure. I've got 3 years of experience as a geotechnical engineering technician. I've got through college in my undergraduate degree in physics, I studied electricity and magnetism, and was on a space consortium with a NASA program through the Fort Lewis College. And then in my professional degree as an engineer, I've got 18 years of professional engineering on specializing in hydrology, hydraulics, river systems, and fluvial geomorphology. Fluvial geomorphology is basically how water interacts and shapes geology.
Could you explain what an expert in hydrology is able to express opinions about?
Well, an expert in hydrology is
You're asking for him to now express expert opinions. You have not certified him, nor did you disclose any potential expert opinions.
That's absolutely a
I
misstatement.
think he's just asking for information about the person. But carry on.
He's asking for an opinion on what an expert may talk.
Carry on.
hydrology is the science of the amount of water, the source of water, the amount of water, and how it moves.
And has your professional experience involved hydrology issues
Yes.
over time?
Yeah, absolutely. Hydrology is one of the tenets of our expertise.
Okay. I would at this time like to offer Mr. Carey as an expert witness in hydrology, hydraulics, and fluvial geomorphology. I would point out that in my pre-hearing statement, I indicated that we intended to call him as an expert witness. So I'm not sure I know what Mr. Justice is talking about.
I think we have a couple bases. First of all, your pre-hearing, joint pre-hearing statement fails to identify Mr. Carey as an expert. He said he would provide the lay witness testimony, was not identified as an expert, and also identified that his testimony would be limited to history of sinkholes, depressions, and subsurface conditions on the Carey tract, basis of objection, installation of grout plugs in the Carey tract, including the Carey pond, and communications. No expert witness testimony was ever indicated or otherwise offered. Moreover, we have not been provided a report which would allow us to either evaluate or refute any expert testimony that Mr. Carey is now offering. This is basically trial by ambush and is generally not permitted. This board should observe the principles often articulated in the district courts that when a party fails to disclose expert testimony such as this, and a party is prejudiced in its ability to defend against it, that testimony should be precluded.
Sorry.
Go ahead, just for a minute here.
Much of this is in response to the testimony that's already been offered and by way of rebuttal. We did not know what they were going to present to the board, and that's what we're addressing.
I object. That is a false statement.
I'd like to finish.
What we're going to do now is I'm going to seek counsel from my colleagues here and see what their thoughts are on this issue.
I'd like to hear from our council.
I think you guys express some thoughts if you do, but go ahead.
We are in the administrative process, which means the rules of evidence and the civil rules of procedure are applied as you deem appropriate, and it's your discretion to follow them or not, as you wish. Done.
I'll just say, so far I wasn't uncomfortable with the testimony being offered, and that was questions about what would an expert, what can an expert testify about? I don't think he was being asked for opinion that we would be expected to give the weight we might give an expert. If it gets into that territory, I agree that there could be prejudice to both the division into SNOCAP.
Agree.
Okay. I'll rule that he can be qualified as an expert witness.
I'm not sure that's what Bob was saying.
Oh, and with those guidelines, right?
Well,
Yeah.
no, I guess I was saying he wasn't offered as an expert witness, and so
Oh, you say he should be disqualified then.
I think he can provide testimony that we don't have to give the weight we would give an expert.
Okay, then we'll go that direction.
So just for clarification on the record, is Mr. Carey allowed to give expert opinions, or is he limited to lay witness testimony on facts that he has observed and has a foundation to speak to?
What's the difference, John?
As a lay witness and as an objector who filed against the TR in this matter, I would deem him initially as a lay witness to give us his facts, his first sense impression, and what he witnessed, observed, and understood. The question here is, can he also provide expert testimony based on his own experience and profession? I'm not aware of anything that would prevent that. I know, and I'll take into consideration Justice's objection that this is testimony by ambush, and I'm going to look back at the pre-hearing statement later. I don't have time to do it now, to see whether Mr. Stutz did identify his client as an expert, and I'll consider that when I prepare the order.
Mr. Roberts, if you'd like, I can provide you with a copy of the pre-hearing statement specifically identifying Mr. Carey as a lay witness.
If you wouldn't mind.
It also identifies him as an expert witness in detail. If I can read from that,
We're in this pre-hearing statement.
right here. Pre-hearing statement of objector Jason Carey. And we have here a paragraph on Jason P. Carey, P.E. will testify as an expert witness concerning all aspects of the objections and claims made in connection with this administrative matter. Carey, if you let me finish, please. Carey has owned the property during the period of time that widespread subsistence has taken place. His testimony will include rebuttal and impeachment of other lay witnesses and expert witnesses. Goes on to talk about his experience in this area of hydrology and where he's testified in the past, as well as his educational background. And this is not testimony by ambush. This was filed.
When was this?
Mr. Stutz, can you identify for me the page from your pre-hearing conference
It
statement?
is the pre-hearing statement of objector Jason Carey. Mr. Justice keeps referring to a joint pre-hearing statement.
Okay, so it's a different document that I'm
What we're
looking at.
talking about.
Okay.
Then we have been misled as far as what the sort of testimony would be with a joint pre-hearing statement. I did not receive this second pre-hearing statement from Mr. Stutz.
Well, it was sent to Mr. Justice by email on April 6th, 2017. And that's the certificate of service. I did it myself. So I don't see where there's any sort of ambush here. We didn't have anything to opine on at the time we designated him as an expert witness.
So then the opinions you're going to offer have failed to be disclosed and is again trial by ambush.
We didn't know what the opinions were going to be until we got to this hearing.
Let's see if we can find the document.
I do have a pre-hearing statement filed by Mr. Stutz on behalf of his client that does identify on page 2 to page 3 that Jason Carey is an expert witness concerning all aspects of the objections and claims made in connection with his administrative matter, and it goes on for several more lines. I think you're entitled to certify as an expert.
I'll certify him as an expert.
Thank you. Are you the owner of the property that's affected by TR 69, Mr. Carey?
I'm not the owner that's affected by the proposed repair plan. I was part of the investigation, so we were affected until that proposed repair plans come out. It looks like the proposed repair is entirely off of our property on TR 69.
How long have you owned the property?
We've owned approximately 13 years.
Is the property located over the South Portal Mine?
Yes, it is.
Have there been instances of ground subsidence on your property?
Yes, there is.
All right, and where have these occurred?
I guess we'll need a map for that. We can. I could use this map that's up.
Sure, that's fine. We don't
I
need to
think
be.
this is B10 possibly. Can I borrow your laser pointer? Thanks.
Can I ask a quick question? Is this with regards to the adequacy of the testing procedures or the adequacy of the proposed plan?
Both.
Okay.
So the property here, the property line comes approximately in between these two running north-south. So we have a joint property line with track 71. Again, everyone's familiar with this map up here. So there is a large subsidence zone that exists all in throughout here. There's a large area that's subsided. There's additional areas that have subsided along here and out in this area of the property.
While we're looking at the map, east would be on the right side of that diagram, would it not?
Yes, this map seems to be oriented north and south. So east is this direction, west is this direction.
Can you tell the board which way that property slopes from the area that's proposed to be repaired, plug, and your property?
The area generally slopes to the east, slightly to the north and east. The surface area does.
So is the pond lower or higher than the proposed repair area?
The pond on the surface is lower than the proposed, the surface of the pond. And when a hydrologist talks about the pond, we talk about the wet pond, the water in it. The water surface is higher than the, it's all entirely lower than the elevation of the shaft, than the top elevation of the shaft. The bottom of the pond appears to be lower than the bottom of the repair elevation proposed in TR 69.
What's the significance of that?
Well, although the surface slopes generally to the east and northeast, the subsurface slopes generally to the, although the surface slopes to the west and the northwest, I think I misstated that earlier. The surface slopes to the west and northwest. The subsurface slopes to the east and then in the northeast. So the groundwater, the water movement flows back the other way.
Have you ever conducted any tests to determine whether there is any hydrologic communication between your property and the mine workings?
Well, inadvertently, we of course have filled the irrigation system, filled the pond, put water out, and then through that in 2014, we had water coming out of the mine portal. And that was the conclusion that water applied on the surface was coming out of the mine portal. As far as subsidence on the surface goes, we have performed surveys to identify those subsided
Projection relevance
areas
of the surveys of subsidence.
Go ahead, about those.
Okay, and so inadvertently, and then the conclusion to that hydrologic communication, of course, was shutting off the water to the entire irrigation system subsided the water leaking in the portal.
How much water was applied to the surface over this period?
Well, that so the common agreement was 4 CFS for 30 days. So a CFS is a cubic foot per second. 4 CFS is approximately 1,800 gallons a minute. And for 30 days, that's approximately 7,700 or 77 million gallons of water. I do think it was more like 238 acre feet, which is another conversion, gallons and cubic feet. 238 acre feet, or so an acre of water stacked 283 feet high.
Tell me how you calculated that.
So the calculation is cubic feet per second is the amount of water per second. And then time, and I can give you the actual. So times that amount of water times let me give you in actual days. So in 30 days, there's actually 2,592,000 seconds. And so that, and then at 4 cubic feet per second, that equates to 10 million.
Or about 8 foot a day.
Yes, you're right. So another way to convert it is 1 CFS is approximately 1.98 acre feet per day. So 4 CFS is approximately 8 acre feet per day. 8 acre feet times 30 days is 240.
Yeah, gallons are an illusion, you know, I mean, it's a nice way of saying a lot of water, but I want to know the acre feet, so.
Yeah, so 240 acre feet approximately, using round numbers, was applied. But that does equate to 77 million gallons. And that is relevant because of the amount of gallons, and we'll get to that. So because we've used gallons earlier to talk about 10,000 gallons being applied to the testing procedures.
Well, how many acre feet were applied in connection with the testing?
Let me try and calculate
based
that.
on your being here during that.
All right, let me just, if you don't mind me running a quick calculation. So, so approximately 10,000 gallons is about 1,336 cubic feet.
Is that more or less than 1 acre foot?
It's less. It's about 3% of an acre foot.
Okay.
It's about 3% of an acre foot.
Now, while the irrigation was turned on, you had occasion to observe what was happening at the pond.
Yes, yeah. So I was out there in late May over Memorial Weekend, and we had water running and filling up the pond and the irrigation system of 2014.
Did you ever observe the pond overtopping?
No. The pond doesn't overtop, and the pond is actually a structure in the irrigation system. The issue out there is that there's cliffs wrapping the property there. And so any kind of return water we have to capture from the pond to try and prevent it running over the cliffs and down onto I-70. And so the pond helps capture and infiltrate that water and keep it from running overland down to I-70. It's part of the irrigation system that's always been there.
Is that also designed to keep water out of the Colorado River? This irrigation water?
Well, it's really designed to try and keep it from running down off the cliffs. The Colorado River is down beyond the highway there and into the.
Were you ever asked to turn off the irrigation water?
Well, I wasn't asked specifically, but Rudy Fontenary, he manages the ditch. He's our ditch manager, and he was asked to turn off.
What were the circumstances?
My understanding was that there was water coming out of the portal, and there was a concern of the safety of the mine.
Was the county sheriff concerned about this?
Yeah, my understanding was that everybody was concerned about this as a safety issue that potentially.
What were they concerned might happen?
Well, I think there was uncertainty, but I think that they recognized that water was building up in the mine, and that potentially if water came out of the mine in a rush, it might flood the highway or cause flooding problems down gradient.
Part of that, would it be blowing out the structure that held water back into the mine?
Objection, he's requesting speculation on operation engineering with respect to mine reclamation and otherwise, saying blowing out this. This is also undisclosed expert testimony meant to rebut previously disclosed and timely disclosed testimony by Snowcap's experts.
I sustain the objection.
All right. In any event, you did turn the water off. The water was turned off.
I didn't turn it off, but it was turned off.
Okay. Now, is it your expert opinion as a hydrologist that the water that was going into the pond eventually communicated with the mine workings and flowed out the portal?
I'm going to object again, undisclosed expert testimony to things that should have been basically provided with as a rebuttal or otherwise, like Snowcap's experts. After receiving expert reports, we sought leave to file rebuttal opinions. Mr. Stutz and Mr. Carey at no point sought to disclose or otherwise provide rebuttal opinions that they might be used at the hearing.
This is pure rebuttal because they said there's no communication between the pond and the mine workings.
Go ahead, you can go ahead.
Yeah, I mean, we don't know where the water goes. We do know that a substantial amount, 238 acre feet, subsides into the ground. We know that it does not come out of the cliff face. It does not come out of any other location. The only location that we've ever seen it come out of as return flow is out of the portal of the mine.
So you're telling me that when you put water in your pond, that there's no way out of there?
There's no way out of there. So that's a key point. The pond is the terminus of the irrigation system, and it's there to prevent water from flowing uncontrolled downstream of there. We do flood irrigate out of the pond and irrigate the fields, but we have to do that in a manner. There's about 10 acres of field downstream of the pond, and we have to do that in a controlled manner. And we have another catchment and burrows to catch that downstream of that. But we can overwhelm that and cause water to flow off.
Will the proposed revision in TR 69 stop any hydrologic communication between the pond and any of the mine workings?
Objection, foundation.
Sustained.
I don't understand the objection.
He's done no testing to otherwise determine that there is in fact a hydrologic communication otherwise. He's provided no evidence regarding the effects, the hydrology, the geology, or otherwise the movement of water from the pond, and has submitted no testing that would allow him to otherwise offer this opinion.
Well, we've got testimony that from the applicant, from Snowcap, that there is no hydrologic communication between the carried between the Kerry Pond and the mine workings. And my question is, will the proposed technical revision have any effect on that?
I sustain his objection.
Can you comment on the speed with which the pond emptied, based on your observations?
Well, the pond empties relatively quickly. I don't know the actual speed, but as others have mentioned, it drains out in about a week's time.
Excuse me, when you say drains, where does it drain?
It goes subsurface. It completely soaks into the ground.
Go ahead.
Can you comment on the adequacy of the testing procedures that have been employed that you've heard about in the hearing, and confine your testimony solely to what you've heard here?
Yeah.
I'm going to preliminarily object. I'm sure you'll let it go, but he hasn't disclosed these opinions, critiquing or otherwise, rebutting why, and we have not been provided an opportunity to challenge.
That's your question again. I didn't hear it.
Yeah, just can you comment on the adequacy of the testing procedures used to determine, to correct the problem of water seeping into the mine? And solely based.
I'm going to overrule his objection. Go ahead.
Okay.
Yeah, I would like to comment on that. It looks like they've done a lot of technical things to evaluate the connection from one hole to the shaft. But we know that there's multiple areas where water goes subgrade in the system. The problem with the ERT testing is that void spaces in the ground are air spaces. And when they're dry, they show up as blockages. But in reality, those air spaces are the conduit for the flow of water subgrade. And so in the testing procedures, they identified one hole in a dry condition and wetted that one hole with 0.03% of an acre foot, and then proceeded to test. All the dry holes showed up as obstructions or no hydrologic communication because they were not communicating water at the time. The one wet place that was communicating water at the time, they saw that connection and they came to the conclusion that our wet hole communicates water. Now, when we applied water and we recognized that water was coming out of the portal, we did that at 238 acre feet. We didn't even have the whole system saturated. We didn't have all of the fields saturated. We didn't have all of the areas saturated. We just had the main ditch and the pond saturated. And that took 238 acre feet.
Wait a minute, let me object. I want to ask you about the 238 acre feet. So what you did is you accumulated 30 days of water and you release it all at one time. That's what you're telling me.
Not at all. I
mean, 238, it takes a month to accumulate 230 acre feet.
Correct. For 30 days, 4 CFS was soaking the ground. Because the ground is so porous there, we have to build up the groundwater in order to get the water to hold on the surface. And so that took 238 acre feet to fill all those dry voids. So testing the system in a dry condition after it was, the conclusion would be that only your wet areas are communicating the hydrology.
That's all the questions I have.
Mr. Justice? I'm sorry.
Scott Schultz on behalf of the division. Mr. Carey, again, you stated that back in 2014, over a period of 30 days, that you applied 230 acre feet or 77 million gallons to Track 71 in your property, correct?
I did not apply it, but it was applied.
Okay. Is there any sort of gauge on the Kerry Pond as somehow indicating how much water is going into the Cary Pond?
We don't have a gauge directly on the Cary Pond, no.
Okay. And you referred to the Cary Pond as part of an irrigation system, correct?
Correct.
What does the Cary Pond irrigate?
Cary Pond does not irrigate anything.
Did you or Mr. Fontenary ever plant any crops on Track 71 or anywhere at the site?
Yes, crops have been planted and irrigated on the site in the past.
When?
I don't have specific dates.
What was planted?
There's been a range of vegetation.
Nothing more specific than that? A range of vegetation was planted at some point in time?
Correct.
Is it sometime in the last 10 years?
Not in the last 10 years.
What during this 30-day period in 2014, again, 230 acre feet you said were used. What were you applying this water to?
That water was all return flow. It's soaked into the ground and back into the hydrologic system.
I'm confused. What are you applying the water to?
The water, the ditch was being maintained, and so the ditch was turned on to get the water flowing in the ditch in order to start applying it to the fields. It's the typical practice of getting the system running. And so the water was shut off before we could apply it to the fields.
So 77 million gallons were utilized over a 30-day period to clean this irrigation system, or to prep this irrigation system?
I would say prep the irrigation system.
Okay. Do your water rights allow storage in the Cary Pond?
Yes. Not my water rights, Ms. Onarian.
I'm going to object to that. That's beyond the scope of this record examination. We're getting into what is water rights.
I'm going to overrule that. I think he's asking some pertinent questions here.
Now, Mr. Carey, you stated that the ground of this area is porous, correct?
Correct.
Do you know what the geology of the area that is?
Yes, I do.
What is it?
So the Pinedale glaciation brought down, these are colluvium deposits of Pinedale glaciation over the mine work, over the coal mines and the Rawlings sandstone.
Do you have any knowledge as to whether your pond would hold any water, even if there was no mining done, any underground mining done?
Yes, we have knowledge that the pond holds water.
Do you have any knowledge that the underground mine at all affects the level at which the Cary Pond drains?
We do not have knowledge of how the underground mine affects the level at which the Cary Pond drains.
Have you ever performed any hydrologic communication tests regarding the Cary Pond?
No, we have not performed any hydrologic communication tests.
You stated that the hydrologic communication, in terms of the hydrologic communication, you do not know where the water goes.
Correct.
That's placed into the Cary Pond.
Correct.
Okay. No further questions. Thank you, Mr. Carey.
Thank you.
Just for clarification, and maybe I misheard, but I heard you mention that you did irrigate when it got to a certain level of the Cary Pond. And yet now I just heard that you probably haven't had a sustainable crop in the last 10 years in there. Just clarify that for me. I'm a little confused about, and it's pretty hard for me to just accept the statement that there's vegetation there. I'd like to know if it's alfalfa or weeds.
Yeah.
We need some I think in this picture.
And that would be a question for Rudy Fontenary. given permission to Rudy Fontenary to maintain the irrigation system and
But you're the one that said there was something growing there. I don't, you know, what would it be?
in the crop. We've got full diversion records for what's happened there. So
That's what it is today.
I can't tell you what that is today.
Now, what, can you tell me, how much water the Cary Pond holds when it's full?
I can't tell you that.
I mean, you don't know if it's an acre foot or 10 acre feet or.
It's approximately 10 acre feet. I don't have it.
And I did hear, I think from you, and correct me if I'm wrong, that water, if not current, I mean, not water running in other words, if it was sitting there with no new water running in, would usually dissipate within about 10 days. Is that correct?
Yeah, approximately a week's time.
Okay. Any other questions?
I have a question. When you're saying that dissipates, is that going completely dry?
Yes, yeah, it soaks into the ground.
And it only soaks in, it's not draining off to some other place?
There's no outlet drain from the Cary Pond.
Okay.
Gary, John Justice, Richard McCabe. First question is, you haven't done any seepage studies to identify the rate of seepage from the Cary Pond.
Correct.
So you don't know what volume of water may or may not have seeped from that pond in June 2014. Do you?
I do not.
Okay, based on what you said, at max amount over a period, you said it was a 10 acre foot pond, and it could seep at a rate that would allow 10 acre feet, approximately 10 days to seep. Over a month's time, that would reach approximately 30 acre feet. So would the remainder of that water have had to have been transmitted down the trench?
Well, I think there's a differential rate of infiltration depending on the head in the pond. So it infiltrates faster the deeper the water is.
Okay.
And the question was, how long does it take to go dry?
Okay. This isn't a lined pond, is it?
It is not a lined pond.
But yet, Mr. Fontenary ran 4 cubic feet per second for a month and accomplished no beneficial use.
I'm going to object to that. That's from legal conclusion.
Did he apply that water to the land other than running it
Can I
from
have
the
a
pond?
ruling on my objection?
Yeah, I want to hear his question again, though. Let me hear me.
So I'm asking it based on Mr. Carey's testimony. It appears to me that for a month long, 238 acre feet, the public's resources was diverted, driven down this trench. There was no effort to either stop the flow or otherwise remedy the problem other than to let it run into the mine. And that it was not actually applied to the lands for its decreed purpose of irrigation, but instead allowed to run down the line. That's exactly what I heard, is that none of this water escaped the trench with the volume.
Is that a question or an argument?
I'm going to overrule you. I don't like the way that question's phrased.
Okay.
I'm going to overrule you.
Did any part of the 238 acre feet you suggested was run down to this area, was it applied to irrigation purposes on the lands owned by Mr. Fontenary or yourself?
I don't know.
I have a question. Of that 230 acre feet, am I correct? Some of it went down the ditch, some of it went into the pond.
Correct.
Do you know what proportion went in? Right.
I would estimate that 75% of it goes into the pond, about 25% of it went into the ditch.
Just another question. You know, I meant to ask him earlier. We say there's 4 CFF that runs through that ditch. Do you have a record of that? I mean, the way things run, you get 4 CFS today and maybe 1.5 foot tomorrow. And do you have a head gate record of that?
I do not have the record of that. So I was going mostly on Mike Boulay and Rudy's estimate of that.
I just have one follow-up question on Karen's question. It's what's your basis for this 75-25 breakdown between the pond and the ditch? How do you get that estimate?
Just the pond is on the main channel. The pond's the main channel, and most of the water flows into the pond.
But again, the pond doesn't have a gauge.
Yeah, again, that was just a approximate.
Trench doesn't have a gauge either.
Neither of them have a gauge.
And in fact, this trench that we're all talking about, that is some of the water goes to the trench, some of it goes to the pond. That the trench no longer exists. Is that correct?
I don't know. The last time I saw it existed.
When's the last time you were out at the site?
Let's see. I don't know the date exactly. I think it was late April this year, April 2017.
And then my follow-up question is, so in late April, that trench still existed when you visited the site?
The last time I visited the site, the trench existed.
Okay. No further questions.
Is this the trench that is on photo 4, photo 5? C.
Correct. I believe the trench we're all talking about, for clarification, is just to the east of the Cary Pond here, and this is approximate layout of it in blue. And I would, from my observations of the site, I agree that I think Exhibit C-4 and Exhibit C-5 show that trench. Is what I observe.
Mr. Carey, I have one follow-up question on this breakdown of 75-25. When the pond has been filled, and the elevation is raised to the point it is backing up, would the breakdown of 75-25 be appropriate if the infiltration rate limits the capacity of the pond?
No, I think the pond infiltrates faster the higher the water in the pond is.
So are you suggesting it will infiltrate at 6 acre-feet a day?
I don't know what that rate is. As I stated earlier, we do not have measurements on that.
You don't have any information on that?
You asked me that earlier, and I answered that question.
Thank you.
We have a backbench question here.
If I may.
Go ahead.
Mr. Carey, can I stand?
Sure.
Mr. Carey, you have been asked questions about the adequacy of the ERT testing conducted by Fugro. And we have testimony that was conducted in April and August of 2016.
That's
You
my
have to
understanding.
answer yes or no?
Yes.
Okay. You have reviewed the reports of Fugro from their testing in April and August of 2016?
I'm going to object to this question as Mr. Carey, given the information that we did receive regarding an expert, there's nothing in his endorsement that talks about ERT testing.
Let me ask it differently. Should there have been a different method of wetting the soil in order to conduct ERT testing?
I continue my objection.
Sustained.
Nothing further.
We'd like to break to consider rebuttal testimony at this point, particularly given the late nature of what has been provided in testimony by Mr. Carey, and may bring Mr. Hill back to testify.
What's our time real quick, John?
Absolutely. So referring to the pre-hearing order, we are at objector's presentation, which is E. Of the 2.5 hours that is allocated there's 1 hour and 18 minutes left for that. Or do the objectors anticipate more witnesses? Are we closing up here?
We are not calling for
It's just us calling anymore?
I don't anticipate anything, but it depends on what happens with the.
Well, you still have the rebuttal option later on, but this is just
I'll
initial presentation.
Retain the option, but I really don't think we'll.
Okay, so this is me making a check mark on E. We're closing that up.
Wait, no, I don't want to close it yet,
Okay, we're not closing it up.
but you can keep going with your,
I'm done.
okay. I think the board would really appreciate if the objectors could take some of their time here that they have in their 2.5 hours to summarize their arguments regarding the adequacy of testing procedure and the adequacy of the proposed plan. 3 minutes each, just really break it down for us. I feel like we're getting off on all these tangents. I need you to focus back in on the two things that we're looking at today.
May I proceed?
Please.
And John, according to the pre-hearing order, responding to a question, it's not a matter of time.
Clock's not running.
The basis of our objection is this. In order for ERT testing to be successful, there must be water applied to the soil. Whether it comes from rain, snow, or anything else, there must be water and there must be clay, because water is a conductor and air is a resistor. All that happened in this situation was to dump water down a sinkhole. One sinkhole out of the entire size of tract number 71. That's all that was done. Our contention is that to have done it correctly, and they had the opportunity, they should have had Mr. Fontanari do flood irrigation from the eastern edge of tract 71, allowing for a 3 to 3.5 week period for water to absorb into the soil, and then conduct your ERT testing to determine where there are in fact subsurface anomalies. Instead of doing that, and they had the opportunity, the ideal opportunity, 2016, they never requested, they never gave us notice at all of when they were going to do this ERT testing. Ironically, we were out there the day before, April 5th, instead of April 6th. Nonetheless, they didn't do that. They had the opportunity, had they done it, would have then been able to determine the presence of hydrologic connections on lands owned by Mr. Fontanari. But instead of doing that, they came in with a preconceived notion before they even contacted Fugro to do the ERT that all of the connection was at the air ventilation shaft, a man-made structure. That is the basis of our challenge, that the ERT testing was not done in a proper manner. Yet they had the opportunity to do it, they had the people to do it, all they had to do was ask.
And your argument on the proposed plan?
And proposed plan, it should be much broader. Secondly, that plan, if you put in a plug, is not going to correct the problem of this soil. What's going to correct the problem of this soil is water management. Because the problem is too big, in our opinion, for snowcap to feasibly and economically try to plug in every hole that is on that property. No.
Okay.
And that is why we had an alternative plan. I'm not trying to argue the alternative plan, John. I understand your ruling. When you asked me about the plan and the testing, now you understand where we're coming from. And that is what Mr. Carey is talking about.
Okay, thank you.
On behalf of Mr. Carey, I don't think I need to comment anymore on the adequacy of the testing. We find it to have been faulty. I will comment on the remedy. We're objecting to it because I don't know if everybody's familiar with that kids game called whack-a-mole, where you pound on one and one pops up somewhere else. That's the approach that we think is being taken here. We're correcting one source of hydrologic communication, and not all the water is going down there. The pond is another source that should have been dealt with under a plan. So it's not that there's anything wrong with TR 69 standing in of itself, but it doesn't solve the problem. We don't want to be coming before the board every time one of these depressions or sinkholes appear. And there are sinkholes all over this property. We'd like the plan to be a little bit broader, and that's our objection.
I just want the record to be clear in terms of this is Mr. Beckwith's test. This is him making argument.
Argument,
This is
absolutely.
not testimony. He did not even cross the applicant's expert, and he provided no testimony about any sort of ERT testing, any sort of witnesses whatsoever. So
I understand.
I'm not sure if he wants to open himself up to cross, but that is purely argument.
I understand. It was more along the lines of what I felt should have been presented at the beginning as an opening statement, and I'm taking it
Completely
as
understood. Thank you.
the argument. Well, it provides for a presentation of your argument. So I was just asking for a conclusion of all of that.
So just to bring us back to where we are, to find out where we are, it looks like we are completed now, Jill, with.
Yeah, yeah.
All right, so we will proceed to F after a break. Fortune is going to take a break.
We'll go to 5 after.
Great. Thanks, Jeff. Thanks, Seth.
This court.
You need a binder handler.
Wrangler?
Binder wrangler. Enough water.
Oh, sure. So I know y'all came here to see me copy a PowerPoint over onto the desktop.
It's okay.
I think we have enough time. Thank you. Got 2 teenage daughters. I can talk really fast if I need to. I can't listen very fast, but I can talk fast.
That never helped.
Okay. Figured you were waiting on me. Thanks.
Just make it again.
For the record, my name is Jim Stark. Again, I'm a senior environmental protection specialist with the division, and this is the division's rebuttal to what we've heard yesterday and today. So there was some discussion from Mr. Carey about subsidence. I just wanted to reiterate that mining at the roadside south portal area was room and pillar. And again, room and pillar mining by the act and the rules allows for controlled subsidence of the area. And under the act,
I'm going to object to this. I'm sorry, this is a legal argument. This is not rebuttal evidence and rebuttal testimony as required under a rebuttal restriction. The number F, the division shall have 1 hour to make a rebuttal statement and shall be limited to responding to issues addressed in the presentations of the parties. None of the parties have argued these statutes.
Well, the statutes are relevant to why we're here for the application for TR 69. And also, subsidence was clearly gone into by Mr. Carey and Mr. Stutz's presentation. So this is clearly relevant.
They went into it relative to a factual matter, not relative to legal argument.
Well,
The witness is not qualified to legally argue these statutes.
I'm gonna overrule you on that. We're gonna.
and I'll just clarify that this isn't legal argument. This is the statute. This is the statute and the rules.
Okay. So CRS 3433-122, parent 2, parent A, parent I states that an operator should adopt measures consistent with known technology in order to prevent subsidence causing material damage to the extent technologically and economically feasible. Again, the same statute, parent 2, parent A, parent III states, nothing in this section shall be construed to prohibit or interrupt underground coal mining operations. Down arrow here. Then if we go into the rules for surface coal miner, for coal mining, rule 2.05.6 parent 6 parent A, which is mitigation of impacts of mining operations, that's the broader section, states that for undergrounding mining activities, the application shall include an inventory of all structures and renewable resource lands which exist within the proposed permit and adjacent area. It further goes on to state, if no such structures or renewable resource lands exist, no further information need be provided in the application. And again, Rule 4.20.1 parent 1 states that nothing in the rule shall be construed to prohibit the standard method of room and pillar mining. Where does all this lead us? There are no regulated structures under the Act and the rules on Track 71. The rule and the Act are very specific. It's structures or renewable resources. The ditch Mr. Fontenary dug prior to the June 11, 2014 inspection is not a regulated structure under the act or the rules. Again, the Cary Pond is not a regulated structure under the act or the rules. Additionally, the ditch and the pond were constructed after mining had happened there. So with the knowledge that the area had been undermined. So we're going to talk a little bit about the post-mining land use in the area. Again, it was discussed that this area is going to be irrigated for some reason. Again, just a little rule, a definition from the rules, 1.04 parent 71 parent H, hotel. Defines fish and wildlife habitat as land used wholly or partially in the production, protection, or management of species of fish or wildlife. The approved post-mining land use for the surrounding lands disturbed by snowcap are generally fish and wildlife habitat. And I'll show you some maps and I'll explain the generally when we get to those maps. Post-mining land use for TR 69's minimal 0.4 acre disturbance is also fish and wildlife habitat. The post-mining land use at Mr. Fontenary's adjacent gravel pit is also fish and wildlife. So that general area is a fish and wildlife habitat. So this is a horrible map. It's the entire pre-mining land use map. I'll point out a couple things. The kind of blue crosshatch there, that's fish and wildlife habitat. And you can see the majority, this is west of I-70, but you can see the majority of the area is fish and wildlife habitat at the mine. The red crosshatch is commercial industrial land use. I'm going to go to a blow up of the area in question. So here's the Cary Pond, that the Fontenary Trench would be right about here. So you can see the disturbances roadside has created out there, all fish and wildlife habitat with a little bit of industrial commercial at that area. That was the pre-mine. Now we go to the post-mine land use, same thing, the large scale map just to kind of show the post-mining land use in the area, fish and wildlife with some sprinkled industrial commercial. And the blow up of that map again with, so you can see what we're talking about. And this industrial commercial here, that's the Cocopelli fruit stand. It was originally in the permit as fish and wildlife habitat. They came back, applied for a permit revision and received approval to have that changed to commercial industrial. So what we're talking about here is we're talking about fish and wildlife habitat. Again, this area is not cropland. Rule 1.04.71 parent A defines cropland as land use for the production of adapted crops for harvest alone or in rotation with grasses and legumes, and includes row crops, small grain crops, hay crops, nursery crops, orchard crops, and other similar specialty crops. I mean, we heard testimony that in at least the last 10 years, there have been no crops planted up in this area. There is nothing up there that is cropped. The area is, as we heard from Mr. Stover, the area is predominantly cheatgrass and other annual weeds. And the 0.4 acres that they will be reclaiming will pretty much be the only patch of native grass in that track 71 area. Rule 1.04 parent 110 defines renewable resource lands as aquifers and areas for the recharge of aquifers, area for agriculture or silviculture, production of food and fiber, and pasture lands. And again, track 71 and specifically the TR 69 disturbance area, it's not cropland, it's not a renewable resource. So we go back to the rules in the act. Renewable resources must be protected, croplands must be protected, prime farmland must be protected. This is none of those things that we're talking about here. Further go into this argument in an exhibit that Mr. Fontenary had provided. It's a report, Exhibit 24, the Walter report. Really, it shows the geology of the area. There were 15 drill logs that were taken.
I'm going to object. The Walter report is not in evidence, and Mr. Walter was never called to testify. I told you that yesterday.
It is part of the record, but we can move on. That's no problem.
Let's do that.
Yeah, all right, I'm gonna blaze through 6 or 8 slides here, so bear with me for a second, please. Okay, irrigation of track 71. So basically, there's no irrigation on the site. Mr. Carey testified that the water flowed in the ditch and into the Carey Pond. There was no water applied to this surface. No irrigation takes place out there. Why the water was run at 4 CFS or whatever that number was for 30 days is, it remains a question. Again, it's not relevant in the overall picture of things, but it's something, you know, to consider.
And once again, I'm going to object. The first paragraph of Mr. Fontanari's response is not in evidence as an exhibit. The second paragraph, the district water commissioner found that the district water commissioner has never testified. This is improper rebuttal.
I don't believe it's improper rebuttal, and we have a picture. I think it's the next slide. That's a fact, issue of fact that Mr.
Let me see the next slide. I want to hear, because it's our job to collect the information we need to make a decision. And I understand where you're coming from.
And I recognize, Mr. Chairman, and that is very important, which is why I appreciated Ms. Van Noort asking me the question. But I don't have, what am I going to do on testimony that has never been presented to you on a district water commissioner? On water commissioners making findings that there is no evidence of any such findings being made. The water commissioner locked out the head gate, but he's never testified as to why. Therefore, this is improper. I am now.
Let me hear from you.
I disagree. This is not improper. I mean, there's talk from the presentation by Mr. Carey about this being used in X, Y, and Z manner. I think this shows that it wasn't used in a proper manner. It's direct evidence. This is a picture taken by the division. This is part of their decision to approve Snowcap's application. So the objectors have, you know, the reports that they haven't submitted. They submitted to DRMS that are not submitting to the hearing, but the division still made its proposed decision, and that goes to the proposed decision. There's been numerous objections and comments made by the objectors. These are simply responding to those.
Please note the date of the proposed decision.
One moment, please. Mr. Schultz, is this PowerPoint presentation in hard copy and evidence? Do you know? Please.
Sorry.
Thank you.
No,
That they said weren't.
DRMS file. The picture is a part of DRMS's file. However, the rest of the PowerPoint is not being offered in as evidence or as an exhibit.
Mr. Beckwith.
Please note the date of this document, March 6th, 2017. The proposed decision was rendered in January 30th of 2017. This document could never have been considered in the proposed decision because it did not exist prior to that.
That is correct.
This is a bootstraps argument.
No, what Mr. Schultz was saying is we used all of that information that was provided before or previously. This is going to talk of the beneficial use of the land. On or around this date, we received a call from the operator saying what water was running in that ditch again and was not being used for any irrigation. It was being run in the Fontenary Trench and going into the Carey Pond. It was Miss Hammond called up, Tanya Hammond from Snowcap. She called us up and she said, this is happening. So I ran out there and we walked up to the head gate. We kind of looked at the surface, walked up to the head gate, and this note was there. And it just goes to the point that there's no irrigation happening out there. It was not used.
I want to ask a question. Thanks.
Sure.
Can you help me understand why the beneficial use is important to the 2 points we're looking at today, to the testing procedures and proposed plan? I know it's come up a couple times. I'm having a hard time connecting the dots.
I think the plan is very specific. It's to stop hydrologic communication.
Okay.
I mean, we've talked about that, and I think you understand that based on your question. The assertion is that with hydrologic communication, they cannot irrigate these lands. because the water will simply disappear into the mine or wherever it disappears. I think that's the issue with the irrigation or with the objectors. I can't speak for them, but that's my understanding of all of the documents I've read.
Okay.
So if they're using water and there's no beneficial use, there has to be a beneficial use at some point, according to the water commissioner.
Mr. Chairman, I've got to speak in addition to this whole lot of questions. What is it rebutting? I mean, this is new evidence being offered from the water. Not to go this way. And I appreciate the need to get all the facts out, but we're trying to operate under some appropriate rules.
Mr. Chairman, we submitted the Fontanari repair plan. We made various arguments and contentions in it. This board, and I'm not arguing with your decision. This board and the pre-hearing order said all of that is non-jurisdictional. It's immaterial. We are not going to discuss it. Where Mr. Stark is saying these contentions were made is in the Fontanari repair plan. I'm not allowed to argue that to you. So why am I facing rebuttal testimony on argument that I am not even allowed to make to you? That is not only improper, it is highly prejudicial.
I'll respond very briefly. Mr. Beckwith didn't provide any presentation. Reminded the board of that. But Mr. Carey and Mr. Stutz did. This is in rebuttal in their claims about irrigating track 71 in the Carey Pond. However, we will move on.
I ask that
I'm going to skip over this stuff because this is
just bear with me.
remade.
I ask that the board strike that portion of the testimony that we have objected to because it is prejudicial and improper. And you've already restricted me from even arguing about it.
Again, this isn't rebutting Mr. Beckwith's presentation. He had no presentation. However, Mr. Carey and Mr. Stutz did. And there was it's stating that there's no beneficial use to that irrigation.
That's not part of MR 82.
I'm going to overrule that and we're going to move on.
So just, again, I just want to recap Snowcap's TR 69. It's for a hydrologic communication repair plan, again, based on the ERT study conducted by Fergo in April of 2016, reviewed by Huddleston Berry. HBET agreed that the study showed that there was an historic vent shaft that was causing the hydrologic communication at that location, at the end of the Fontanari ditch, going into that vent shaft. The division believes that the data reviewed is sufficient to conclude that the current extent of hydrologic communication is expected to be the total extent of hydrologic communication. That's out of attachment 16 from the SL8 findings. So that was the division's statement when the commitments to study the hydrologic communication were originally put into the permit document or put forth to be put into the permit document. Again, a second ERT study was conducted in August 2016 by Fergo. And the total proposed surface disturbance is 0.4 acres out there, just a very small area. Snowcap will provide an additional surety bond for that surface disturbance. Again, the proposal, it's to excavate from the subsurface hole to the historic vent shaft to a depth of approximately 16 feet. We heard Mr. Stover say that they may go deeper depending on what they find. At that point, they will pour a 12-inch thick concrete pad over the vent shaft. They'll backfill and compact that excavation. They'll replace the topsoil on the area, and they will reseed that 0.4 of an acre. Again, we have, based on a mine map, we have a vent shaft location, and based on a Fergo study, they verified that location of that vent shaft. Again, it's in that area. And we've seen this a couple times. It's just the repair plan. It just shows the extent of that repair. It shows the extent of the work that Snowcap is planning on doing. And the division believes that Snowcap, under their proposed TR 69 plan, did use adequate testing procedures to determine the hydrologic communication or connection between the surface water and the mine workings. Also, Snowcap's plan as proposed will adequately repair the hydrologic communication between the surface water and the mine workings. Again, we're talking about that area, the area where the hydrologic communication was observed in the June 11th, 2014 inspection. And with that, I think the division is done, and I'll field any questions that the board may have.
Can you remind me of the process once all of this work is done? They're aiming for a release at this point of and get their just like what happens if once they get the revision in, they do all the work, then what happens at that point?
Then we wait for the grass to grow. I mean, literally, and I don't.
Yeah, no, I know.
Look, it's done. If we find that it doesn't work, then we go back to the drawing board.
Okay.
But if it works, then, which we assume it will, I mean, we have every reason to believe it will, then it's just a matter of waiting for that area to be reclaimed, for the grass to grow up and it to be releasable.
Okay.
Mr. Beckwith.
Thank you. SL08, was that rendered in 2014?
I don't know. I was not involved with SL08. I don't know.
And for the record, SL08 is not in evidence as an exhibit. The testing was done in 2016.
Correct.
And you brought it up onto the board. Did that indicate that there were 4 sinkholes that Fugro identified? Would you bring it up again?
Yeah, I'll bring it up, but I'm not an expert in ER. Oops, sorry. I went one too far.
Don't have to be an expert. In the lower left-hand corner of the picture on the left-hand side, what does it say in red letters?
Sinkhole surface expressions.
Objection, he's asking about Fugro's testimony and what they did. If you would like to have the cross-examination of what Fugro found and what their documents represent, he should ask Fugro.
I'm asking questions based upon this gentleman's presentation. And this is part of his presentation. It's open for an entire examination. You wanted information.
I'll sustain it. Go ahead.
Thank you.
Go ahead.
I'm not allowed to ask that?
No, I said I sustain it. Go ahead.
No, over.
No, you are allowed to. I'm sorry. I apologize.
In other words, John's overruled. on his
I'm
there we
sorry.
go.
Yeah, I overruled.
Thank you, sir.
Sustaining your.
Did the picture on the left, does that come from Fugro?
It does.
And the picture on the right, does that come from Fugro?
It does.
And the picture on the left, does it say down in the lower left-hand corner, surface subsidence, surface sinkholes expressions?
Sinkhole surface expressions, yes, it does.
And does it identify these by the round red circles?
It does.
And it shows 4 of them, does it not?
It does.
And they only dumped water down 1.
I don't know. I was not out there.
You've read their
I
report.
read the report.
Okay, and you reviewed their report
I
for
did.
purposes of making a proposed decision?
I did.
And did you make any factual findings in your proposed decision?
We don't actually make a
In
written.
other words, you didn't make any.
We don't. It's
Thank you.
a finding of fact is not required for a technical revision.
For a proposed decision.
No, it is not.
Okay, so your division did not make any factual findings.
Because we're not required to. So no, we
Understood.
did not.
You did not make any. You
All right.
complied with your rules.
Right.
Okay, and so on the right, does it also show these same 4 sinkholes?
It does.
And you reviewed that report too, did you not?
I did.
And did you review the report and see that they only dumped water in April of 2016 on the left down 1 sinkhole?
I don't recall when they did the rock pile. They did 2. They dumped water down 2 holes.
That was
Or
in
2
August.
features. Okay. I don't recall which one, but I know they did at one point dump it down 2 holes.
Now, with all of your argument, with all of your presentation and rebuttal, relative to reclamation, does that, your discussion of reclamation, would you please explain to me how that establishes the adequacy or inadequacy of the ERT testing that was conducted in April and August of 2016?
I'm sorry, would you repeat that?
Sure.
At least the last part.
Your presentation had to do with reclamation and the absence of beneficial use, the absence of crops being irrigated, et cetera. Am I correct?
Correct.
Correct. And we are engaged here, are we not, on two questions: the adequacy of the testing and the adequacy of the plan to address hydrologic connections. In MR 82, are you familiar with that document, Mr. Stark?
82, yes.
What did Snowcap commit itself to do to repair?
In a general sense, I mean, I can read it. I couldn't
Please read it.
quote it for verbatim.
Ask them what exhibit is it?
MR 82?
MR 82 is already in evidence.
Please provide the witness with the document.
If I may,
No.
you have a copy
No.
of the actual exhibit?
They're on our computers.
Oh, I'm sorry. I'm sorry. Just a minute. See if I've got one here. Bear with me. In here. That's fine.
So I'd just like the record to reflect that Mr. Beckwith is showing Mr. Stark
I've shown it to him.
MR 82, one page of MR 82, page 14-30-II.
Are you familiar with the language of this document, Mr. Stark?
Excuse me, I am.
And what did, in terms of the hydrologic connection, excuse me, in terms of MR 82, did Snowcap agree to inspect, report, repair, submit estimates of repair and time relative to hydrologic connections on lands owned by Fontanari?
I'm going to object to this question. He's asking for a conclusion of a document that is, I'm not sure how many pages, but it's many pages. So if you could narrow your question.
Certainly. Does it? Let me put it a different way. Snowcap commits to conducting an investigation. You already have this in evidence. To determine the extent of the hydrologic communication existing between the underground workings.
Objection, are you testifying, Mr. Beckwith?
No, I am reading from an exhibit. And the properties overlying the underground workings of the roadside mine, also known as South Corner Mine, and the properties overlying these workings that belong to Mr. Rudolph Fontanari and Mr. Jason Carey. Where in this document does it say that Mr. Fontanari has to irrigate his land?
It does not.
Where does it say in this document that he has to grow crops on his land?
It does
That's
not.
irrelevant. That's irrelevant. Let's
Understood. Let me ask it a different way then, Mr. Chairman. Your testimony about the reclamation, how does it relate to the adequacy of the testing conducted by Fugro?
Which reclamation are you talking about? I mean, there's two levels of reclamation.
You've already testified in your document up here on the board about your reclamation, reseeding and all these others. How does that relate to and how does it establish the adequacy or inadequacy of Fugro's testing?
The reseeding is mutually exclusive from Fugro's testing.
In other words, it does not, does it? How they reseed and what they reseed with does not relate in any manner to whether or not Fugro adequately or inadequately tested this property to determine the presence of hydrologic connections.
I'm going to
Is that
object.
correct?
This is, go ahead.
It doesn't, but any surface disturbance per the act and the rules must be reclaimed. That surface disturbance
I'm not
cannot be
disputing
left
that.
out there. Surface disturbance has nothing to do with testing procedures. So I would agree with that.
Thank you. Nothing further.
I guess I'm troubled here. Could you explain to me, what different did you do in this particular case, I call it case, it's not your observation and your due diligence in finding a solution for a problem that you do daily. That's part of your job. I mean, you follow the statutes, you've done whatever. I'm confused about, did you go outside of those guidelines? I don't know. I mean, it sounds to me like, I mean, from what I've seen so far, that, you know, we do as a staff and we do as an agency what we normally do, and that's protect, you know, let's protect what we're trying to do in Colorado. And is there something, am I missing something here?
No, you're correct, sir. So we receive a revision or an application for a revision from an operator, kind of do our completeness, which is required, and then we review those documents. We review them for technical adequacy. We were submitted 2 separate reports from Fugro, from HBET, information from the operator. We review those. We send out adequacy questions based on our review. The operator responds, and we could potentially send out multiple adequacy letters at that point. We didn't in this case. And then if we find that they adequately address the act and the rules, we approve or propose a decision to approve. And that's what we did here. We did nothing outside of the normal on this. And we believe that they've met the act and the rules in what they've done. This, again, TR 69 is meant to solve a very specific problem. That specific problem is the hydrologic communication observed going in this hole, trying to poke Elaine in the eye with the laser, and then going down that vent shaft. That is the specific problem meant to be addressed by TR 69. So,
You know, I've heard, you know, and test, and I guess I have this latitude. I just,
You do.
you know, I've heard, well, there's all these porous holes and I guess you used your expertise and this department's expertise and your knowledge over the years and I've noticed you've always been very diligent. Not that I always agree with you, but you didn't cut any corners, and we're not doing something funny, and this is not strange. And anyway, I'm sorry, I'm just an old country guy from Pueblo, and I don't know what the hell's going on.
No, we didn't cut any corners. In fact, we even took some extra time on this, extended the proposed decision date so we could look at it further. So it was quite to the contrary of cutting corners, I think.
I apologize. Go on.
No. I'm just on questions now. So again, any questions the board may have, I'm more than happy to answer.
Anything else? Sorry, Donna.
No.
Okay, where are we now?
Schulte, anything further on the rebuttal?
Nothing further on rebuttal from the
All right,
division.
we're done with F. G is the objector's rebuttal. And subtracting the time for that extensive cross-examination, Mr. Beckwith, you've got an hour and
We both have an hour.
20 minutes.
I will defer to,
And I'd like to see if we can find a place in about, half hour, 45 minutes, or we could break for lunch if you find a comfortable place to do that. Unless you want to break now,
we can break now, return at 1 o'clock.
that'd be fine with me if you guys are all.
No, that's long. Let's move it up to like 12.
Oh, okay. It's only 20 till. If we could get here at, say, 12:30, 12:40, something like that. Is that 12:40? Would that work?
Try 12:45. That'd be all right?
I compromise all the time. So.
I know, so do we. Thank you.
Thanks.
May I leave my materials here? Certainly.
Jim, would you ready? Can I expect you to any rebuttal?
No, I've already indicated I would.
All right.
History.
I know.
Yeah, some work.
I don't stop.
He was characterizing the meeting. And I want to understand what characterizing the developments of visions testing.
what's asking?
So he's trying to get there. So he's trying to get there.
Stereo, please. That's heroes. It's,
It's an MR82.
So it was December 2015. I might just. We don't have olives.
You know, like it, and let it go down to the ditch, and then it goes, you know, it kept going around.
I saw you kind of walking together.
93, and yeah, the first one we did not, but it didn't watch it. The rocks.
Just get some lunch, Katina.
I don't know how you do it.
Not that I think
You like it. Oh, I love it.
You like that part of the
I love it when you shut him down. I want to bring out.
That I globbed onto.
There are several things in MR82 that I feel like are.
So if you want to get into it, I think there was.
Just the one page.
We
Maybe I'm looking at SL8.
This LA's right here.
Because MR82.
Looking for text. It's right here.
Okay. We'll be back.
Okay.
Okay.
I'm just gonna stay here. Can I leave my briefcase for it? Yeah, go ahead. Don't go anywhere.
Good job, good job.
Reached over.
That direction.
Yes.
Okay. Well, that helps. I think I will maybe argue from.
What you got to do?
Yeah, where's gonna be? Do. That's just. I'm sorry.
I'm trying to wear your food.
Hey, that's right.
My wife always says she dressed me up, but you know that story.
Just set the table. Just like Thanksgiving dinner. Hey, Jim. I'm going to provide you with this. This is from this is PR. Take a look at it when you get a chance. Basically, it's just a quick one page plus a paragraph that says they have complied with the abatement. Well, no, even if they withdraw. Okay. Sorry. Do I get any more specific with you? Yeah, it's been a while since. I would say it's not, they submitted their paperwork.
So we would go up on Friday night.
Yeah. As soon as this is over. We would go.
No.
You know what I mean? But there's no. Yeah.
Yeah.
evidence is in the form of a transcript. So I don't understand the distinction between record and whether it's an exhibit or evidence.
If I may explain.
Okay, go ahead.
I've had issues where in the past, matters have had to go on appeal. And one or the other party has a matter that was presented, not admitted, but it was presented, and that party is arguing that it created prejudicial error against him. The problem for the court is what was presented. And the PowerPoint itself is not a printed document like we had in the three prior, A, B, and C. And that's why I'm asking that it be preserved, so that if I have to refer to it on appeal, the court has something that it can turn to that Mr. Stark was referring to, rather than all of the parties trying to paraphrase what it was and what it looked like. That's all.
Chief Justice?
I'm sorry?
My response is that most of what Mr. Stark had on the board, or in fact, all of it was verbiage that he basically testified to the extent it was testimony and allowed. The remainder of it, and I feel like that was adequately captured by the court reporter. I don't think there's any need to submit a PowerPoint that was not submitted into evidence or otherwise request to be submitted into evidence. Mr. Stark's testimony is the evidence.
I'm not asking that it be evidence. I'm asking that it be preserved. That's all. And that is a common procedure in trial practice.
I think we're going to deny it.
Okay, Scott?
I am seeking to have it's Snowcaps Exhibit A-9. Move that into evidence. It's the July 1st inspection report prepared by Mr. Boulay. There is in both of the exhibits A and B from the division, which is already into evidence. Those pictures are taken from the inspection report. I haven't had a chance to talk with Mr. Stutz about stipulating to that, but Mr. Beckwith and Mr. Justice are in concurrence with that.
I have no objection to it, Your Honor.
Mr. Stutz?
Okay.
Okay.
No objection from Snowcat.
Submitted.
I've already indicated that Fontanari was deferring to Mr. Stutz relative to any rebuttal. Mr. Stutz, are you presenting rebuttal?
No rebuttal.
Okay.
We're up to H on the pre-hearing order, which is the applicant's
Applicant's
rebuttal.
rebuttal.
All right, first I'd like to call Ms. Tanya Hammond back. And Jim, would you be able to put that back?
Oh, yeah, I'm sorry.
Beta.
I apologize.
No problem. Yeah, bravo.
Bravo, page 10.
Sorry. Squeeze it between you guys here. You want to sit here, Jim? To make it easier for you.
I'm just driving this real quick.
Certainly. You're a good driver.
Well, that's my wife.
She's not around. You can admit it.
That's right. I am a great driver. Presentation.
Okay, go to that page.
This page?
Please, thank you.
And could you enlarge it? There we go.
All right, currently we have on the board Exhibit B, page 9. I'd like to ask you a couple questions concerning the application or release of water into the Fontanari Trench, both in April of 2016 and also in July of 2016, just prior to Fugro's ERT testing. Would you please indicate with, if there's a pointer,
It's
oh, right there, indicate with the pointer where Snowcap dumped water in April of 2016?
Okay, in April of 16, we used a water truck to dump the water. It wasn't a hose. It was like a water trunk with the water truck with the sprays. And we dumped the right about in here at the beginning of this, at the end of this trench, right before the major, what do we call the sinkhole that most of the water was observed going into in June of 2014. And so it took about 5 loads forth to Palisade to get water. So you'd put the 2,000 gallons in, go back, get water, so it had time to saturate and get into the ditch. It was for preparation for the ERT report. That
And
was April.
when you did that, did it just go down the, well, I'll call it the primary at the northeast corner of the trench?
No, the primary is I call the middle one. There was one on this side of the ditch. I'm sorry, I'm shaking also. But, so the water went into this one, it went into this one, and it turned the corner and got all of this little area right here wet also. So it went down all 3 of those. April did not, no water went into that one in April.
Okay. How about in August, is it August, or July? What, where did Snowcap apply water in preparation or food gross testing at that time?
We did basically the same thing, except we only put about 8,500 gallons in this area here. And then we had decided to put some water in here to see what happened. So we put 1 truckload, about 2,000 gallons in this hole. And it did go down at first, but then it built up and then it started free flowing on the ground. So at this hole.
Okay.
I'm sorry, I didn't see it.
Okay, let me see if I can hold it steady.
Which hole is that?
That's the expressed sinkhole. Rock pile is what I call it. This one right here.
And where is that located?
It's close to the U water line.
Okay.
So, yeah,
And how much water again was placed down there?
approximately 2,000 gallons,
Okay.
1 truckload.
Nothing more, Miss.
Okay,
Nothing, no questions.
okay,
All right.
Thank you.
okay.
Oh, we have a question here.
You say 3 holes. The first one, I see 2, and then where's the third one?
Well, they've got 3, there were 3 little circles here.
There are
Okay.
3 holes. There are 3 circles.
Okay, and yes, there's 3 circles here. There's one, they're in very
Oh, I
close
see. You're
proximity
right.
of
I
each
see.
other.
Okay.
So the water went into all 3 of those areas
I see what you're saying.
when we dumped the water. They're really close to each other.
I understand. Thank you.
Okay.
Any other questions from the board?
Okay.
Mr. Hill, would you please? Sure. Mr. Hill, were you here for the testimony of Mr. Jason Carey?
Yes, I was.
And did you hear his observations on the ERT analysis conducted by Food Grow?
Yes, I did.
Do you have any responses or contrary opinions to what he stated or additional items you'd like to explain?
Yeah, there is one. It's kind of implied that as water is introduced to the ground, it goes into the pathways that are migrating from the near surface down to where it happens to go at depth, that once the water is turned off, there is a very quick draining, almost near real-time draining of the pathways of water fluid. Now, I'm not a hydrologist, but due to there's a complex interaction of the water, the rock volumes, the hydraulic permeability, the mineral content of the pathways, which result in the electrical resistivity measurements that are obtained. My contention is that even after the water has been.
It seems to me that this is the testimony that a hydrologist is competent to give, but not. Overruled. Go ahead.
All right. The point is that after you turn off the water or stop feeding water to the thing, there should remain within the pathways some residual water. Like I said, the length of it is, well, I will admit, is beyond my scope to say how long it remains there, but it should be some finite time afterwards. So we would still see this interaction going on. It would vary off over time. It would likely lessen in the amount of resistivity. The resistivity would increase. The amount of electrical conductivity would lessen over time in all likelihood. And because the way this water is removed is through gravity, that the upper portions of the area would become have less and less water in them over time, and then it would migrate down. One of our, we couldn't perfectly re-energize these systems with water in the time period we had in the amounts, but enough to put it in there and try and start to recharge the upper portions, at least of these systems, which would be the ones expected for most of the drainage out.
So in conclusion, notwithstanding the criticisms of Mr. Carey, do you feel like the ERT survey conducted by Fugro is still a valid analysis and would have effectively identified any subsurface anomalies?
Yes, it would have identified anomalies if they existed.
Okay. Thank you.
Yes.
No questions.
No question.
Any questions from the board?
Okay, you're excused. No more rebuttal witnesses.
Thank you. That takes us through H on the pre-hearing statement, or pre-hearing order, I'm sorry. Takes us to I, which is the division's closing.
Absolutely.
You can sit there. This is fine. 1 second here. Okay. Again, I'm Jim Stark, Senior Environmental Protection Specialist with the division. Sorry. So again, the reason we're here, surface owners, property owners, Mr. Fontenary and Mr. Carey have objected to the division's proposed decision to approve Snowcap Coal Company's application for TR 69 and requested this formal hearing. And the background again, on our DRMS inspection of 6/11 of 2014, water was seen flowing into a new ditch dug by Mr. Fontenary and into a subsurface hole. This water was later suspected of entering the roadside portal, south portal area through some subsurface hole. Again, the division estimated up to 54 million gallons entered the mine at that point. So Snowcap's TR 69, it's not about possible subsidence damage or irrigation of non-arable lands. It's not about any alternative plans. It's not about trust funds. And it doesn't seek to, oh, he didn't talk about any of this stuff, sorry. Sorry, we didn't talk about that stuff. I'm gonna go right with that. Snowcap's application for TR 69, it's very narrow in scope. It's basically about fixing hydrologic communication that was noted on June 11, 2014. That hydrologic communication was verified by Furgo's investigations, and it's also verified by HBET. The application for TR 69 has a minimal 0.4 acre surface disturbance. Snowcap will post the necessary bond for reclamation for this surface disturbance. So water was seen flowing in this east-west ditch. Some of that water was flowing into the Carey Pond. Some of that water was flowing in this north-south ditch that was dug by Mr. Fontenary. Water was going into this subsurface hole. And water was then later determined, not on that inspection, but at a later date after studies, found to be going into this historic vent shaft. So Snowcap's plan, as proposed, used adequate testing procedures to determine the hydrologic communication or connection between the surface water and the mine workings. The plan also, as proposed, will adequately repair the hydrologic communication or connection between the surface water and the mine workings. The application has met the burden, the applicant has met its burden to establish that their application is in compliance with all the requirements of the Act. It's also accurate and contains all of the information required under the Act and rules, and all of these requirements have been complied with. And they have demonstrated that reclamation required by the Act can be accomplished under the reclamation plan. I mean, really, to sum up here, 2 Furgo studies concluded the source of hydrologic communication that was seen on that June 11th inspection, June 11, 2014 inspection, as an historic vent shaft. The studies were reviewed by HBET and Snowcap. The operator will repair all surface disturbances as well as the hydrologic communication observed. The Act, the rules, the Furgo studies all support Snowcap's application for TR69. So today the division is asking you, or requesting of you, to make a final decision to approve Snowcap's TR69 application to repair the points of known hydrologic communication. Yep, that's it. Again, if there are any other questions from the board, I'd be happy to answer those.
Okay, thank you.
All right, thank you.
That's right. Me. In many respects, well, first of all, may the record reflect. So, in many respects, I've already given you a summation of what has been presented to you. There are a number of pieces of evidence, a number of pieces of documents that we request that you have already reviewed. For example, figure 3, there's been a lot of discussion relative to where this water was dumped. I ask that you look at figure 3 from the April 2016 and July 2016 Fugro reports. They are very, very specific, and they also show photographs of where the water was dumped. If the water being dumped down the rock pile was so important, why did Fugro never make a photograph of where the water was dumped? Fugro instead said, here it is. This is the air ventilation shaft, and in both April and in August of 2016, they used the identical photograph. Our contention is that there were inadequate methods to comply with MR82. MR82 is where Snowcap committed itself to inspecting, reporting, and making repairs of hydrologic connections existing on lands owned by Rudy Fontanari and Jason Carey. MR82 does not identify any particular sinkhole. It does not identify any particular tract owned by Mr. Fontanari, and Mr. Carey only had one relevant tract anyway. In doing so, they went out, they did an inspection, and by the time they're doing the inspection, they have more sinkholes than were involved in June of 2014. Now they have 4. They don't investigate them. They don't dump water down them. They don't ask for irrigation water to be flooding the land to saturate it in order to have high conductivity so that they can determine whether there are any other sinkholes. As a consequence, the basis for TR69 is flawed. Mr. Chairman, you have mentioned that you feel your obligation is to get all the information you possibly can to make the wisest and most practical decision. That, of course, has to be done within the scope of a formal hearing, rules of evidence and everything else. And having to deal with technical objections that I may make to John and John may make to me or Scott may make. What is important is why did not that same attitude extend to Fugro? Fugro was given one specific location to test, dictated by Mr. Berry, who made that conclusion before he ever examined anything from an ERT inspection. He told him to investigate air ventilation shaft because, as he testified, his working hypothesis was it could only occur by a man-made pathway, nothing by natural at all, even though all of us have not disputed there are collapsed coal caverns underneath this property in various locations. If you grant this TR 69, then you and I are going to become very familiar with each other over the next few years. Because the position that you put the landowner in is that 6 months from now, if another sinkhole comes up and water goes down that sinkhole in one fashion or another, if snowcap reasonably applies for another technical revision, we're back here all over again. Why should we have been put in that position? What we ask you to do is to deny TR 69 and to say, go back out and reinvestigate this property so that all of the parties can sit down and say, we have damaged property. What is the best way to approach it? What is the most practical use of whatever money snowcap coal has and whatever interest that the landowners have? I can't compel you. I can't even file my own application on behalf of Mr. Fontanari. I can only rely upon what has been presented to you today. And it's not sufficient. Snowcap should be required to do more. And they should have done more. But they did not. Therefore, our request is that you deny TR 69 with conditions, telling Snowcap and DRMS to go back out on the field to do testing. And this time, please give us notice. We're not fighting you. We wanted to cooperate with you, but nobody would give us notice as to when you were testing. And in that regard, I also ask is that if you grant TR 69, you put into your order that they give us notice when they are going to go out and start this digging so that we can observe and collect whatever evidence we feel is appropriate. Thank you. Mr. Stutz?
Supposed to be on here, according to the pre-hearing order, is the adequacy of the testing procedures and the adequacy of the proposed plan. I think we've offered evidence that the testing was inadequate, should have been conducted across these properties to satisfy MR 82. So I think we've got a problem there. From that, we go to the adequacy of the proposed plan. All we're doing is plugging one hole. And I'll summarize our position. We'd like to proceed on something other than the whack-a-mole approach. We'd like a comprehensive look at the property, proper testing, and the ability to come up with a plan that takes care of this so that we're not all living with this thing for years to come. Thank you.
With respect to TR 69, as you heard, it is the endpoint of a process that began with SLA. During that process, as the testimony talked about, a hydrologic communication was observed with respect to water moving from the surface into the coal mines. The only places water was delivered or otherwise applied and from which any hydrologic communication could have propagated from was either from Fontenary Trench and or the Carey Pond. Snowcap is under no obligation to otherwise address these structures or otherwise. This is a situation of no good deed goes unpunished. Snowcap took on the repair in this to avoid and to ameliorate any concerns with respect to safety. There's no requirement that under the statute that Snowcap maintain or otherwise make these lands arable. What they are doing though is they made commitments to investigate the specific hydrologic communication observed in 2014 as documented in the 2014 Boulay report, and it has done so. It conducted multiple ERT surveys encompassing the entire area where water was actually delivered to on either the Carey property or the Fontenary property. So it required them to look elsewhere for evidence of a hydrologic communication where no water was provided, as is being suggested by opposing counsel, would be the definition of arbitrary and capricious. There is no evidence that hydrologic communication would otherwise exist on other locations or properties owned by Fontenary, or Terry. The only location in which there's any evidence or any thought that there might be a hydrologic communication was in the areas investigated by Snowcap. Thus, they have completed that investigation, and they have now proposed a repair plan to address the only anomalies identified in that investigation to prevent future hydrologic communication to the mine. Snowcap has gone above and beyond here to address this problem, and it has completed every requirement both under MR 82 and by the statute and rules to address this issue. I've got nothing more.
I just have a procedural question. You pause your time real quick. I asked you earlier if you could identify the exhibits you offered or wish to offer into evidence so I can get the numbers down.
Can I give you a written summary of that?
You may.
I have no objection to that.
Okay.
Okay.
I would appreciate that. Thank you.
All right. Would the court reporter have those been captured in the transcript as well when I have offered or submitted exhibits and evidence?
Only what you said.
Okay, but I'll give you a summary,
That'd be
a
wonderful.
list as well.
Thank you. We're done. So at this point, if you have no questions for the applicant, we have gotten through all of the lettered steps for the procedural order, or in the procedural order. So if you wish, Mr. Chair, you close testimony and entertain deliberation by the board.
I'll close testimony then. We're sufficiently finished, I suppose. And then any discussion? Discussion from the board? Thoughts? Mr. Randall?
I have a question for John. In this kind of a posture where the division is staffed to the board, to what degree is the board, to what degree is the staff's position entitled to deference? And I'm trying to figure out I wanted to hear all of the evidence first, but now I want to sort of think through the weight we should maybe consider giving to staff presentations.
That's an excellent question. As I'm sure you knew it was before you asked it. You're entitled to give it as much deference as you deem it to be appropriate and informative. I don't believe that it's due to the heightened deference, if that answers your question.
Sure.
That's good.
That's what we wanted to talk about.
Yeah.
I think we really need to just focus on what the issue is before the board, and the issue is whether TR 69 complies with the act and the rules. And then under that, we have the two issues of adequacy of testing procedures and adequacy of proposed plan. And I think it makes sense for us to take each in turn, talk about it, if that works for you. As far as the adequacy of testing procedures, we heard quite a bit of testimony about the ERT testing that had been done. I found that the material that was submitted and the testimony that we heard from the applicant, I found it to be credible, and overall, I found that the adequacy of testing procedures were adequate and comply with the act and the rules. I don't have much more to say than that, because that's what I've come away with after these day and a half.
I have a question. Did you want us to deal with the adequacy of testing first, and then we talk
Yep.
about the,
Yep. Not all at once. Keep them
Okay.
separate. It's easier for John to write
understand?
things when
Okay.
we talk about things separately.
I thought I had trouble with the adequacy of testing. I think it was pointed out several times that there were enough variables in there that seemed to be very, very loose. There was not a controlled testing to a scientific standard. I felt there also could have been other kinds of tests that could have been done. I still think that if it needs to be disproved or proven one way or the other, that the river with the rising and lowering of the water table can affect the amount of water in the different holes. I've seen it on other pieces of property that has happened. I would certainly want that to have been looked at. I was surprised there was only one type of test that was used. And I just did not feel that the testing was sufficient in the number and in the types of tests that were used.
I guess when I think about the types of tests, I deal with, subsurface investigation quite a bit in the work that I do, and we don't go out and do, all of the tests that are out there. You go out and do the ones that you think are going to be helpful, and there always is an economic factor.
Absolutely.
You pick which one's the best, and we heard testimony from Mr. Berry that he determined, based on his experience, that this was the appropriate testing to get the information that they were looking for. And so, as far as the different types of tests, I don't think that changes my mind as that it was an inadequate testing procedure.
I hear your point. I think it's a well taken point. But I usually have found that I'm not saying you do 10 different kinds of tests, but I think that river is close enough that has to be fully discounted, that it did not in any way affect the change in the water conditions there. And I would like that disproven, and then fine, then I would accept the other one. But I think that one other, either that or another type of test could have been done, and it would have been financially within the bounds of efficiency, and would have rounded it out. Or you're going to choose your tests where you think you're going to get results that perhaps you want. I don't know that you go in there saying, well, we'll just find out and see what we're going to do. If you're hired to do a test, you often do the test that says it'll yield the results that whoever is hiring you will want. That's not always the case, but I think when you make some choices, because there are a number of different tests out there, you're going to be very careful how you select those tests, certainly by the person who's, or for the person who's going to be paying the bill. It doesn't mean that you're biasing it, but I think there could have been two different types of tests. I wouldn't say 10, I wouldn't say 5, but 2 different types to justify or tighten up the testing procedure itself. It was awfully loose.
What do you mean it was loose?
The dumping of the water. It kind of, well, we did 10 this time, and then we did 8.5 over here a little later. You plan to do it all at the same time. You do the same amounts in each of those holes. You watch it. It isn't this day this and that day that.
Nothing. I mean, I will just say, I tend to agree with Jill's read on this, that given what we were presented, I think the testing was adequate. And that is not to say that there couldn't be additional tests done, but I think they met their standard to determine hydrologic connection. Just in my view of the evidence that we saw.
I guess in my observation of what staff has brought to us on other situations, I think, kind of understanding a little bit of water situations, I think the testing was adequate. I understand we can go find, many ways to test, but I think they identified with their knowledge what tests it would take to verify the conclusion they came to. In other words, I think they probably thought about different types of testing and, what may be useful and some not useful. And so I feel comfortable with the testimony that was presented in that regard. And I watch staff, and as well as I do, I don't always agree with them, but they're very discerning about what they put together, because they don't want to come back in here and do it again. And so I feel like the tests were adequate.
Talk about the proposed plan.
Go ahead. You're so eloquent, Alan.
I think the proposed plan and looking at the plan, we look at what TR 69 is designed to do, and that's to address the issue that has been identified through the testing that was identified in the inspection. And I understand that the property owners would like to get a much larger fix, a much larger investigation of what may be out there or not, but that's not what we're looking at here. You know, we're looking at a specific issue that was identified, that was further investigated through testing, and the proposed plan, it's going to address that issue as far as I understand. I mean, I'm not a mine engineer, but based on the evidence that was given to us, it appears adequate to address the issue specifically identified. And if we have to come back and do this again, we'll do our jobs. I'm not going to be influenced by the fact that we may have to see these people again.
To me, the adequacy of the testing and of the proposed plan are certainly tied together, though we're looking at them separately. Since I don't agree with the testing procedures, did not feel that they were adequate, the proposed plan doesn't meet that. But even if you take the proposed plan for meeting the tests that were done, I have some serious doubts that that plan will suffice.
Why is that?
I think you have issues there that you're going to have other sinkholes or other areas popping up. You can plug one, and if you're running something, it's going to come somewhere else. You're going to have an opening somewhere else, and you're going to just keep plugging and plugging and plugging and plugging. And I just don't feel that there's been evidence proof that the plugging that they have proposed on the vent will suffice for the whole area. I think they're going to find more things coming up.
That's not what we're looking at. I mean, we're looking at whether it's going to, I mean, I understand that your issues are with the testing procedures and that they haven't identified,
Right.
haven't gone across and maybe identified more issues. But let me ask you a question. If the proposed plan, if you're just looking at the one area that they did identify, do you believe that that proposed plan is adequate to correct that one area that we're addressing?
It'll plug the vent, but I don't think it will prove in the end to keep other openings from coming up when you have the situation. I think the pressure is going to be taken off there. It's going to go somewhere else. And there are other openings that could come up because that isn't a solid ground underneath there.
I'll just say, for me, this question is a little bit easier than the first one. That if the testing is adequate, then the plan to plug it seems to be a little bit simpler mechanics in engineering to excavate, fill, compact fill, compact fill, compact fill. And I guess, Jill, like you know, I believe that this will be adequate to repair the communication. And if it's not, there is a remedy for that too. And again, I'm not interested in partial fixes, but this sounds to me like it will be effective based on the evidence that we heard. And I was moved by testimony about the adequacy of this in order to repair the connection. So, again, the first question was a little harder for me to get through. And this one feels a little more, just a little simpler. The engineering seems simpler.
I guess, I didn't have enough evidence to convince me that it would be fair for us to predict what might happen in the future. And, and I just, that's not our purview, I think, right now. I think the staff has looked at the site long enough and to discuss it with with snow cap and I think, I feel very comfortable with what they presented, the evidence, and I could be wrong. We all could be wrong. But I feel comfortable about, what they did, and I agree with you. This is an easier issue for me than the first one, but, so I accept it. I accept
Yeah,
it.
maybe it's just easier to understand, easier for me to understand.
So any further discussion? Somebody want to make a motion?
I move that the board makes a final decision to approve TR 69 application.
Your second?
Did you second or you asking?
He's asking
Yeah,
for
I
a
took
second.
I'll second.
It's been moved and seconded. All those in favor?
Aye.
All those opposed?
Aye.
Passes 3-1.
Thanks, everyone.
If I may, just a procedure. John, when will you be coming out with it?
June.
I'm sorry?
June.
Well, I would expect that.
I don't know. It's been months in other cases.
No,
Sometime before the end of June. My June is a little crazy. Thanks, everyone.
Thanks very much.
Thanks.
So
That confirms.
Well, thanks for your help.
Do we have more business or
No.
do we need to adjourn?
I think we're adjourned. We adjourned.
Whack it.
Whack them all.
Unless I hear otherwise, we stand adjourned.
Yeah, she doesn't even. Put that bow on there.
Well, we got through it, John.
Great job. I had low expectations, but you well exceeded them.
Well, thank you. But,
No, I'm just-
I wanted to make sure that,
yeah, that's what we're saying. Hold on, take it back.
That's one of the things.
Oh, thank you. For that, without your help. These guys are pretty tough.
Say, gentlemen, why can't we have coffee?
Well, I asked if we wanted to do a settlement meeting this spring, and it never happened. I invited it, and it just, yeah, I remember I directly asked you if we'd like to sit down for that, and it never happened.
When was it, in April 12th meeting?
No, it was,
Because I remember that issue came up in the April 12th.
no, we talked about even meeting at the coffee shop there in Grand Junction
Right.
and visiting about that, and it never happened.
Right.
Because I wanted that heart-to-heart talk. And, we have posturing and everything in our pleadings,
Yeah.
but there's always a subcurrent there, and let's talk about that. And it's sort of what I would call principal bargaining, and we may not be able to get there. I understand that.
It's always true.
But at least it tells us,
You see, like what Walter said. Have you gentlemen discussed settlement? And then he backed up and said, wait a minute, that's not applicable under the old rules, it's under the mineral rules.
Yeah.
And I sat there thinking, why the hell not?
See you guys.
It's the
See you,
same,
Greg.
it's the same kind of issue. So when Jim and I chatted yesterday, before we all started,
Well, I
he
see.
said, I wasn't involved with this.
Thank you all. Thanks, John.
And
We'll see you.
See you soon.
Hey, next time you're gonna give good testimony. I'd like to know about it.
Sorry.
You're a sharp guy.
no, John, there has been a lot of question
Yeah.
between us.
Oh, absolutely.
You're the young man, and I'm the old.
No, it was the very first week we're punching at each other, so I get
Oh,
that.
yeah. So, but now,
Mhm.
now we're headed for other things. And what I'm looking at essentially is that I make the assumption, I'm just talking as attorney to attorney. I make the assumption that Steve is not interested in multiple holes, multiple plugs, multiple repair work of that nature.
We're not, be blunt, we're not interested in repairing the property.
It makes no sense. It makes no sense. As I mentioned at the conference, the property's damaged. Okay, fine, but what does Rudy want to do with the property? All he wants to do is mine the property eventually, as he is doing in Track City, and provide for some type of erosion control. And what we have already embarked on is, among other things, discipline.
to get rid of that cheap grass. Because as you know, cheap grass when it burns, it's
Nasty
highly
stuff,
flammable,
yeah.
but it burns hotter and it sterilizes the ground.
Right. Our position, just so you can understand where we're coming from, is at least with the tracks that are subject to the special warranties in particular,